On the list.
Monday I mentioned one matter. It was item number 42 as hearing first matter. But it is an old matter of 2010. I mentioned Lordship directed me to mention today for fixing a date, any date.
Today is the date for hearing.
No, today is hearing.
Item number 42.
Yes, madam.
You are?
I am for the petitioner. And there is
What
no
you want?
respondent, state is the respondent.
Very good. So what you want? Not today.
No, madam, I want this matter may be hard. Any date fixed, madam, so that this can every.
This is the first matter under the hearing. It can
Yes,
be taken up. Only some applications are there that can be disposed of within half an hour. Only some applications are there. Nothing more than that.
But tomorrow, Lord, you can fix it tomorrow. I shall inform. Otherwise, they will not come. Once we have informed.
Very well. We inform. I will pass not today.
No, tomorrow I will. Lord,
very good. Very good. Not today.
I inform this state.
You inform?
This matter cannot be hard.
Very good.
Lordship, may I permit to mention one matter for judgment? Your Lordship already heard the contempt application made CAV on 20th May, Lordship. I'm mentioning for judgment, Lordship.
Which matter? Contempt application?
Already heard, Lordship. Made CAV on 20th May.
Contempt application?
Lordship.
No, not contempt. No contempt is pending. WPA 222.
Already heard. Hearing is concluded, Lordship. Made CAV on 20th May.
Let me check. Okay.
Lordship.
My lord, may I be permitted to mention two revisional applications that have been assigned to this bench. The next date is on 8th September in the lower court. And there are two matters which need to be heard analogously. So my lord fixes any date next week or the week after that for hearing the matters, for inclusion in the list.
For inclusion.
Just put assigned matter.
All assigned matters. Yes.
May I have your lordship's leave to mention, my lord? I am mentioning upon notice, my lord. This matter, your lordship will recall, was mentioned last week, my lord, on Wednesday. But your lordship, since takes land matters on Thursdays and Fridays, have directed us to mention today.
So, what is the matter?
Lord, this matter is appearing as item number 43 today. There is an order of status quo upon the Kolkata Port Trust since 2012 with regard to possession of the property, my lord. My lord, the only thing, my lord, the petitioners have done is once they have obtained the order in 2012, they have not proceeded with the repetition till 25, and there is a status quo order. The Kolkata Port Trust is suffering, my lord, 2 crore rupees every month, my lord, on account of revenue.
So, what is the status?
My lord, status it is ready for
everything complete.
Ready for final hearing.
Then let it start this matter today.
Well, it is 43, my lord. I was only
43 is the second matter of hearing matter.
It could be fixed.
First matter will not take it up today. The accommodation is short for it will be taken up today. This is the first matter.
Well, in the event, my lord, if it falls for your lordship, if it is not taken up, your lordship will to fix the date and time, my lord.
Tomorrow this matter can be taken up. Today this matter can be. Let me call the matter.
Very well.
Let the petitioner come.
Your Lordship, may I have you kind leave to mention item number 81 today, Your Lordship. All pleadings have been completed in this matter, Your Lordship. If a time could be fixed or if it could be fixed today, even, Your Lordship.
No, I cannot assure. Item number?
81, Your Lordship.
Last matter, last part one matter.
Yes, Your Lordship.
This is 22.
It is unlikely to be taken up today, Your Lordship. If all pleadings have been completed, reports has been filed.
There are old matters. 2010 matters, 2012 matters, 2015 matters.
Your Lordship, I appear for the respondents.
2022 matters.
I appear for.
Let's see today. How far we can go thereafter and fix a date tomorrow.
Your Lordship, then I may have your leave to mention at the end of the day, Your Lordship, for fixing.
Okay, you come.
Grateful, Your Lordship.
Yes, call the list. IRC Natural Resources Private Limited and another versus State of West Bengal.
Yes.
I'm for the petition number.
I am reading only the operative portions.
Yes.
Accordingly, writ petition is disposed of. The impute notice dated 30th January 2019 regarding termination of joint venture agreement issued by the respondent number 4 is hereby quashed. Respondent authorities are hereby directed to transfer the mining lease in favor of respondent number 7 in accordance with the joint venture agreement dated 24th of November 2014 within a period of 4 weeks from the date of passing of this order. Read petition along with the connected application.
Lordship, may I just indicate, Lordship has directed the corporation to transfer the lease. It is the state government because state government is the lessee.
Not 7. Not respondent number
No,
7.
no. State respond number 2.
Respondent number 2 it would be.
Yes. Secretary, Department of Commerce
Very good.
Industries,
In
because they are the lessee,
Okay.
lessor rather.
They are the lesser.
Yes.
In accordance with the joint venture agreement.
Yes. Your Lordship has directed respondent corporation instead of direct the state
Respondent number 2.
2 or state respondent.
Okay. Respondent 2 or state respondent.
Yes.
Okay.
Good.
Next.
Lordship, I am for the petitioner. This is an application for extension of interim order, my lord.
I am for the respondent in this matter, my lord.
Your Lordship, the difficulty is this is a expired sand mining lease. Lease has expired in 2022. Interim order has been passed subsequently. By way of interim order, these respondents have been restrained from allocating the subject sand block in favor of any third party.
What is the status of the incident matter?
So the pleadings have been
My lord,
completed.
pleadings have been completed. We are also ready for hearing, my lord. In the meantime,
Because
time extends for a short
Extend
period,
the
my lord.
interim order, the purpose of the
Interim
petitioner will not serve, not the state respondent. They are
for a short period, my lord.
losing revenue.
We are also ready for hearing. Fixes any date, my lord. In
It's a
the
very
meantime,
short
my lord,
matter, Lordship. Kindly give some precedence because the entire royalty.
Tomorrow?
Lordship,
Ready?
my lord, next, not this week, at least next week, my lord.
Tomorrow, kindly read.
At least next
I
week, my lord.
know you will submit like that.
Yes, because they are enjoying the interim order.
Interim order.
Because I am taking only 2 days.
My lord, at least next week, my lord.
Tomorrow there will be no such list. I will complete the all pleading, all applications.
Lordship,
today.
kindly
kindly
keep this
read
matter
tomorrow.
tomorrow. Let them.
My lord, at
Kindly
least
read
next
to the
week, my
matter
lord.
tomorrow.
At least next week, my lord, because
Who is
my
leading you?
senior- Joy Chakraborty, Mr. Joy Chakraborty, my lord.
Lordship, Mr. Chakraborty had a talk with me. He said that today he has some difficulties. So only he will pray for
Not today.
extension. Lordship, kindly. Mr. Chakraborty is here.
Yes.
I'm late by-
Can it be done tomorrow?
In this matter,
Take your breathe first.
I have engaged.
The matter is here.
Yeah, next week any date, my lord. Tomorrow
Next week, any day, then I will fix the matter 12:30 on next Thursday.
Yes,
Grateful.
12:30, that will be better.
Yes.
And interim order till that.
Yes.
my lord.
Please take down this matter appears under the heading of extension of interim order. Learned counsel appearing on behalf of the state submits that the matter is otherwise ready for hearing. So it is not necessary to extend the interim order further. Having heard the learned counsel for the parties, as the affidavits have been completed, as the pleadings have been completed, let the matter appear in the list for hearing on 28th of August 2025, 12:30 p.m. as a specially fixed matter. Full stop. Next para. Interim order passed by this court on the earlier occasion is further extended till the adjourned date.
Grateful. Grateful.
Next.
Your Lordship, for the petitioner, Your Lordship, affidavit of substance. This is my extension of interim order application. Your Lordship, my affidavit in reply is due to be filed. I was praying 2 weeks' time to file the same. Meantime, the interim order could be extended, Your Lordship. I'm facing execution. Despite the interim order being there, I'm facing execution. The order was passed on in
What
January.
is the interim order?
Page number 7, Your Lordship.
Page number 7.
7 of the CAN application. 15th of January, Your Lordship had passed it for 8 weeks, which was expiring on 12th of March. And we had filed it, this application on 26th of March. My other side is here, I've served. This is pertaining to gratuity. My company is registered in Kolkata, but the proceedings are being proceeded in Hooghly.
So what is the status of this matter?
Your Lordship, appeal is still pending. I have handed over the copy of the order wherein
What is the, who is the, for the state?
Your Lordship state
My lord, Mr. CC Day and Ms. Reshma Chatterjee is for the state. Mr. CC Day is engaged in another court.
Whether you have placed affidavit in opposition?
My lord, that
no, they have not filed it.
They have not filed.
No, a private respondent has filed.
Private respondent has already filed in the March affidavit in opposition and
Maybe
already
state has to file it.
Your Lord,
have the copy upon the petitioner.
kindly extend
And
the
till
interim-
date, the petitioner has not filed in reply.
If they doesn't want to file reply, so what is your headache?
Lordship,
Is
the
there any
order,
leave to file reply?
Your Lordship,
No
there,
such leave is there.
there was direction to exchange pleadings as state had not filed it. So we were waiting to file a comprehensive reply.
How can it be? If you want to file reply against the
We will file it within 2
opposition of
weeks.
the
Your Lordship, we will
private
file it.
respondent, you have to file separately.
Your Lordship, we will file it in 2 weeks. Meantime, the interim order could be extended, Your Lordship.
Lordship, the matter which has been assailed before your Lordship, the same order has been challenged before the appellate authority. And how the order has been, same order has been challenged with the court.
He has already disposed of the matter.
Your Lordship,
Again, they have filed an appeal in the
No, Your Lordship.
month
It's
of
also a
December.
separate issue.
Your
It
Lordship,
was
that
placed
was a
before me
separate
that
order.
the appellate authority has already passed the order.
I have received a copy that they have filed an appeal in 9.
Dismissed the appeal on 28th of February 2024.
Again, the same order has been challenged before the appellate authority
It cannot be.
parallelly. That's the
Your
paper.
Lordship,
No, piecemeal I cannot take up that matter. I will take up with the matter at the time of hearing. So
my lord, kindly announce us sometime we will file.
what some time you want? How many times?
My lord, I am not briefed in the matter.
Then why you are mentioning this matter? Why you are there?
My lord, I was just
You have to take a proper instruction. Otherwise, you have not appear before this court. You should not. What is this?
Affidavit in opposition.
Affidavit in opposition. Today you are filing this.
Definitely. Already served upon the petitioner in
You are
the
the private respondent number?
4.
Four.
Private respondent number 4.
Affidavit in opposition on behalf of the private respondent number 4 be taken on record. Copy served?
Your Lordship.
Have you served upon the state also?
Also,
Okay, copy served.
Affidavit of service with regard to the CAN application.
Next one, affidavit of service in respect of CAN 1 of 2025. You are for the state. Yes. Where is the affidavit? Shall you use it or?
Yes, ma'am.
You will use it. Very good.
But I filed this. No, petitioner কে ভাই? ও তুমি তো petitioner. না,
private respondent.
private respondent এর পড়া নাই গো। না, ঠিক আছে। পড়া না।
Thank you.
You're lucky then.
Mr. They tell me a date when the matter can be heard.
Any day, my lord, your lordship can fix any day at 12:30, my lord, I must come and complete the same.
12:30 next Thursday I fixed one matter 12:30.
Your Lordship, we
Friday?
will file our reply. Kindly give it 2 weeks
Oh,
time.
You will
We will have to file a reply.
2 weeks. Why 2 weeks?
2 affidavits are there, Your Lordship.
Very
Lordship,
good.
already has been direction has been given to file reply, but till date they have not been
No,
replied.
how filed?
Today they have filed the affidavit.
My
How
lord,
can?
I filed the
Very good, very good, very
in
good.
opposition.
Okay, okay.
That's all.
Please take down.
I have to check.
Affidavit in opposition on behalf of the state respondent number 3 be taken on record. Petitioner is at leave to use reply against both the affidavits within 2 weeks hence. Let the matter appear in the list on 18th of September 2025.
Before Puja, I say, my lord, after vacation, your lordship.
After vacation.
As because
Lordship, it's a
those
gratuity.
on the previous, on the.
There would be several motion matters, Your Lordship.
The matter will be heard by the.
Lordship, it's a gratuity matter. Kindly consider.
Oh, আচ্ছা, ঠিক আছে, my lord. It's gratuity
And
matter.
the
Fixed on.
private respondent has
Very
retired.
good, very good. 18th is just 1 week before vacation.
Yes, ma'am.
Your Lordship.
18th of September 2025, specially fixed at 12:30.
Yes,
Much obliged.
my lord, I filed the
The-
in opposition that order. will be-
Yes, I have passed it. Due to
Interim
affidavit
order
notice-
may be extended till
Okay.
reopening of the court.
In next para, interim order no can 1 of 2025 and headline koro. This is an affidavit of service in connection with the can 1 of 2025 be taken on record. Next para, this is an application for extension of interim order. It appears that this court has passed an interim order
Page 7.
on 15th of January 2025. The petitioner has filed the application being can 1 of 2025 on 27th of March 2025. Considering the entire circumstances and also considering the fact that the matter is otherwise ready for hearing, let the interim order passed by this court on the earlier occasion be further extended till 1 week after ensuing puja vacation.
Much obliged.
List the matter on 18th. What is it, 18th? What is this? 18th, 12:30. Very good.
Yep, see the office part.
Can 1 of 2025 disposed of.
Much obliged.
Next.
I am for the petitioner, this is the instruction. Petitioner does not want to proceed with the writ petition. This is the instruction.
আমি তোমার নাম দিচ্ছি ও অ্যাপিয়ার করছে আমি কাটছি
Please take down. Learned counsel appearing on behalf of the petitioner submits that the petitioner doesn't want to proceed further with this matter. Accordingly, petitioner intends to withdraw the writ petition. Full stop. Learned counsel for the petitioner, learned advocate on record for the petitioner handed over a written instruction of the petitioner. Let the written instruction of the petitioner be taken on record. Next para. Having heard the learned counsel for the petitioner and also after perusing the written instruction of the petitioner, let the instant writ petition be dismissed as not pressed. Interim order, if any, passed by this court during the pendency of the instant petition be hereby vacated. If any.
There is an interim order.
Interim order is there.
yes
Vacated.
This is the connection with the SETA MAT 154.
154
Okay.
at least we get one disposal grateful your lordship
If you want, I can dispose
Lordship,
every
we
matter.
all because of 154
Dispose of it properly.
we are
Pleased to fix the matter on 9th of September. And my learned senior, Mr. Shahara, is giving reply to the
see
Only reply.
reply is going on.
lordship
So we
every day
think
I'm saying this in presence of his junior. Every day, Mr. Saad, learned senior friend, has to say that he will reply. He starts from day one and it never concludes.
Division bench was pleased to
And it never
allow
concludes.
my learned senior to give us chance.
we hope the matter can be disposed of before puja vacation, so that the all matter can be properly disposed of. Yes.
8 September.
Next.
6.
Item number 6, I beg to appear on behalf of the private respondent, my lord.
Let beg to appear on behalf of the petitioner for withdrawal.
For withdrawal. Give me the written instruction.
This is the original, my lord. Withdrawal.
Withdraw.
But with liberty to file afresh, there are certain mistakes in the writ petition, my lord. Non-prosecution.
With a liberty to sue.
With liberty to.
Very good. Learned counsel, learned advocate on record on behalf of the petitioner submits that there are inherent mistakes in the writ petition. Accordingly, he may give in a liberty to withdraw the same with a liberty to sue afresh. The learned counsel for the learned advocate on record for the petitioner handed over a written instruction of the petitioner. Let the written instruction of the petitioner be kept on record. Having heard the learned counsel for the petitioner as well as in presence of learned counsel appearing on behalf of the state respondent as well as the private respondent, the matter appears to be prudent to dispose of the same with a liberty to the petitioner to sue afresh. Accordingly, the instant writ petition is hereby disposed of with a liberty to petitioner to sue afresh on the self-same cause of action.
My lord, the petitioner, my lord, is also present virtually. Reply.
Next.
Your Lordship, I'm for the petitioner, and this is my supplementary affidavit.
What is CAN 1?
CAN 1 of 2024.
What is this?
Lordship, this is a restoration application.
Restoration application.
Yes, Lordship.
And today you are filing what?
Today we are filing the supplementary affidavit.
In connection with CAN 1?
CAN 1, in connection with CAN 1.
Have you served?
Yes, Lordship, we have served the.
Where is the affidavit of service? You have not filed the affidavit of service?
Not filed.
No direction is there.
No direction.
Have you served the CAN 1 upon the opposite parties?
Yes, Lordship.
Have you placed the affidavit of service in respect of service of CAN 1?
Affidavit of service I haven't placed, but.
Very good. You file affidavit of service in respect any connection of service of CAN 1 as well as the supplementary affidavit.
Yes, Lordship.
Okay.
Yes, Lordship.
Please take down supplementary affidavit in connection with CAN 1 of 2024.
No, 7th.
CAN 1 of 2024 be taken on. No. Have you taken leave to file? Okay, okay. 6.
Yes, Lordship. On the previous date, we have taken the leave.
Very good. CAN 1 of 2024
24.
be taken on record. Petitioner is directed to file an affidavit of service regarding service of CAN 1 of 2024 as well as the service of supplementary affidavit upon the opposite part, upon the respondents,
Same.
and file the same on the adjourned date.
Lordship, the state is here as well.
With regard to item 8, I have for the state, not in 7.
This is an analogous matter, is in 7 and 8.
7 and 8 are you are in 7?
I mean 8.
8.
Then who is appearing for 7?
Yes, yeah.
7. Priyavarta.
Why 2? Why 2?
8.
Why 2 writ petitions?
There is a
Both the writ petition disposed of by a single order.
No.
Then?
This item 7 has been dismissed for default.
And what is the item number 8?
Lordship, it is a writ petition that is continuing.
That is continuing.
Yes.
Why it is listed like that?
There is a direction for analogous hearing, madam.
So one matter has disposed of. So how the matter can be dragged with the revived matter?
Lordship, in the two matters, the original writ petition, it has been dismissed for default, and the current writ petition is continuing. So none of
item number 8 is continuing.
Yes, Lordship.
And you are the petitioners of both the writ petitions?
Both the writ petitions.
No.
In the
one writ petition Soumya Chandra and another writ petition Sumita Chandra.
Yes, Lordship. But
you are appearing both the.
Sumita Chandra is in petition number 4 in the original application, and in this writ petition, she is the only petitioner number 1. I mean, only petitioner.
So, who is the learned advocate for respondent in Soumitra Bandyopadhyay Priyavrata Bhattacharya?
That is what I am.
Yes, my Lordship. Soumitra.
That is item number?
That CAN number 124 and arising out of WP number 13326 of 2002.
So
for that matter.
Who is in CAN 7? Who is in 7?
That I don't know.
For the state?
I do not know.
In all the matter you have, you are represented.
Yes.
So far as item number 8 is concerned.
27725.
Yes, this is item number 8.
But where is the? Hey, দেখি দিয়েছেন 7টা কই?
We appeared in item number.
So whether we can heard it today.
Can you fix the date, ma'am?
Lordship, kindly restore this application. They are here.
I will restore the application along with the both the writ petitions.
Yes, Lordship.
You Lordship direct us to appear in respect to I don't know, sir. We can.
You have appeared already in those matters, so it is not necessary to file an affidavit like that.
Yes, Lordship.
Affidavit of service like that, not necessary. Have you served the supplementary?
Yes, Lordship.
You served the supplementary.
I've served, but
Do you have the
I'll give it
can?
to you.
Yes, we have received the
You have the can.
Yes.
Serve the supplementary.
Supplementary, now I am receiving.
Yes.
Supplementary, now I have received, my lord.
Very good.
And my can application has been served, my lord.
Okay, you peruse the
But it is the same matter, Lordship. Just few typographical mistake. For that, we could not do it on the previous date. So, Justice Vivas Patnaik gave us liberty to file the supplementary affidavit.
Very good. So you take the supplementary affidavit, come on next week.
Yes.
Under the same heading, I will here enter both writ petitions.
Yes.
Okay, along with the restoration application. Get ready. Get
Yes,
ready.
Lord.
Please take down. Supplementary affidavit পড়েছি কি দেখো be taken on record. Cut off. Copy served. Your name is Mr. Soumitra Bandyopadhyay.
Led by Mr. Soumitra Bandyopadhyay. I am Priyobroto.
You are Priyobroto Bhattacharya.
Yes, yes.
Mr. Priyobroto Bhattacharya, along with Mr. Soumitra Bandyopadhyay, appears on behalf of respondents. Full stop. It appears that both the writ petitions being number 13326 of 2002 as well as WPA 27725 of 2013 are running analogously. Full stop. Mr. Bhattacharya along with Mr. Bandyopadhyay appeared on both the writ petition as respondent. Full stop. Considering the presence of Mr. Bhattacharya as an opportunity, this court considering the presence of Mr. Bhattacharya as an opportunity, this court fixed the matter for hearing under heading application on twenty-eighth of August 2025 at the same position. This will be hard fast, okay?
Yeah.
Much obliged, Lordship.
Next.
Mr. Ghosh.
Lordship, I appear for Haldia Development Authority in this matter.
I appear for the petitioner. I'm sorry, my lord, I'm appearing today online. I was in some difficulty.
No, you please.
Your Lordship, before the petitioner replies, Your Lordship, may I be permitted to place 2 more judgments, Your Lordship, in this matter?
Today have fixed for reply.
Yes, for us. They have completed.
Your Lordship, may I just small recap, Your Lordship, if Your Lordship permits.
Recap, then let us.
And place 2 judgments, Your Lordship.
You have completed.
She has completed. It's recorded also in the last order, my lord. Not last.
It's just 2 judgments, Your Lordship.
You are for respondent number 4.
1, 2, 3, Your Lordship, Haldia Development Authority.
Respondent 4.
Your Lord.
Respondent who is not willing to
Yes.
use affidavit, but will advance oral argument.
Your Lordship, if Your Lordship recalls, on the last occasion, we had placed the judgment of the Honorable Supreme Court, Rajneesh Kumar and another versus.
You also rely on the same judge, paragraph 10.
If I may place another copy, Your Lordship.
Name on advocate cannot be a ground to condone bail. Para 10 of this judgment can be.
Lord, with leave of Mr. Ghosh, my lord, this judgment was cited on the last occasion.
Yes, Your Lordship. I am.
It was cited.
It was cited on the last occasion. They only cited.
I'm just placing it once more, Your Lordship. Para 10 in page 4, Your Lordship. It appears. May I read, Your Lordship?
Yes.
it appears that the entire blame has been thrown on the head of the advocate who is appearing for the petitioners in the trial court. We have noticed over a period of time a tendency on the part of the litigants to blame their lawyers of negligence and carelessness in attending the proceedings before the court. Even if we assume for a moment that the concerned lawyer was careless or negligent, this by itself cannot be a ground to condone long and inordinate delay, as the litigant owes a duty to be vigilant of his own rights and is expected to be equally vigilant about the judicial proceedings pending in court initiated at his instance. Your Lordship, in this matter, the writ was dismissed off in the year 2021, Your Lordship, and the petitioners have been claiming that it was not to their knowledge till the year 2024, Your Lordship. Kindly also appreciates that they have not given sufficient details or explained the delay which was between those period of time, Your Lordship. Also, Your Lordship, may I place 2024 SCC online SC 513, Your Lordship?
Completed arguments, still you are citing.
Para 26, Your Lordship.
Para 26.
On a harmonious consideration of the provisions of law as aforesaid and the law laid down by this court, it is evident that law of limitation is based upon public policy, that there should be an end to litigation by forfeiting the right to remedy rather than the right itself. A right or the remedy that has not been exercised or availed for a long time must come to an end or cease to exist after a fixed period of time. The provisions of the Limitation Act have to be construed differently, such as Section 3 has to be construed in a strict sense, whereas Section 5 has to be construed liberally. In order to advance substantial justice through liberal approach, justice-oriented approach or cause of substantial justice may be kept in mind, but the same cannot be used to defeat the substantial law of limitation contained in Section 3 of the Limitation Act. Courts are empowered to exercise discretion to condone the delay if sufficient cause has been explained, but that exercise of power is discretionary in nature and may not be exercised even if sufficient cause is established for various factors such as where there is inordinate delay, negligence, and want of due diligence. Merely some persons obtained relief in some matter, it does not mean that others are also entitled to the same benefit if the court is not satisfied with the cause shown for the delay in filing the appeal. Delay condoning application has to be decided on the parameters laid down for condoning the delay and condoning the delay for the reason that the conditions have been imposed, tantamounts to disregarding that statutory provision, Your Lordship. Lordship, their main point for condonation of the delay is that of the period of COVID, Your Lordship. But if Your Lordship checks the dismissal order, Your Lordship, which is annexed as Annexure A of their CAN, Your Lordship, Your Lordship will see, may I just place it, Your Lordship? None appears on behalf of either of the parties. The petition has been pending since the year 2007, and the matter has been appearing in the warning list for a considerable period of time. So it is not that ample opportunity was not given to them, Your Lordship. I am of the view that sufficient notice was given to the petitioner that the matter would be taken up today. It appears that the petitioner is not interested in proceeding the matter. Hence, WPA 23409 of 2007 is dismissed for default without any order as to costs. Even after COVID, even if I exclude the COVID period, Your Lordship, there is a delay of more than 850 days, Your Lordship. And this CAN application, Your Lordship, may I just digress? This application was filed in July 2024, Your Lordship. They are even negligent in pursuing this CAN itself, Your Lordship. It's no.
That's all.
Your Lordship, may I just place one last judgment, Your Lordship? This is 1971 to Supreme, Your Lordship, to Supreme SCC 860, Your Lordship. Para 7, Your Lordship. Para 7. Lordship, from the end, it's 1, 2, 3, 4, 5, 6, 7, 8. 8th line from the end, Your Lordship.
Read out.
Statute prescribing limitation, however, does not confer a right of action, nor speaking generally does not confer on a person a right to relief which has been barred by efflux of time prescribed by the law. The necessity for enacting periods of limitation is to ensure that actions are commenced within a particular period, firstly to assure the availability of evidence documentary as well as oral to enable the defendant to contest the claim against him. Secondly, to give effect to the principle that law does not assist a person who is inactive and sleeps over his rights by allowing them, when challenged or disputed, to remain dormant without asserting them in a court of law. The principle which forms the basis of this rule is expressed in the maximum. Therefore, the object of the statutes of limitation is to compel a person to exercise his rights of action within reasonable time as to discourage and suppress stale, fake, or fraudulent claims, Your Lordship. Your Lordship, they have been negligent and they have not provided sufficient cause for this delay, Your Lordship. Your Lordship kindly appreciates that.
Okay.
Your Lordship, subsequently, Your Lordship, I feel the writ petition has been dismissed after giving them ample opportunity for the matter to be heard out, and subsequently the writ petition should not be restored, Your Lordship.
Yes, Mr. Gali.
Lordship, only a few lines, my lord.
Yes.
In addition to and not in derogation of, my lord, but my learned sister, my lord, has submitted. I do also, my lord, like to, my lord, rely upon this judgment, Rajneesh Kumar, paragraph 10, which my learned sister has already placed before your lordship. So entire blame, my lord, has been cast, my lord, upon the, my lord, learned advocate. If I may demonstrate it, my lord, from the, my lord, pleading, may I respectfully invite your lordship, my lord, to paragraphs 9, 10, and 11 of this condonation application.
Yes.
May I read out paragraph 9, my lord? The erstwhile advocate of the petitioner's applicants further informed the petitioner that during the ongoing COVID pandemic period, matter had come up for hearing on so-and-so date before his lordship. When the said learned advocate was unwell and had completely missed the list of the Honorable Court, and consequently the Honorable Court was pleased to dismiss the petition being number so-and-so due to non-appearance of the parties. The said learned advocate was unaware of such order of dismissal and was under the genuine impression that the matter was still pending till first blame on the learned advocate erstwhile. The poor gentleman is not before us to defend himself, whether he at all was negligent as he is trying to portray. And para 9, my lord, kindly sees, what does he say in the juror, in the affidavit portion? 7 to 10, knowledge. The deponent says it is to my knowledge. Now, what does he say in paragraph 10, my lordship kindly sees, my lord? Paragraph 10, the petitioner applicant state that petitioner applicant have been diligent all along and was unaware of the order of dismissal since it completely relied upon its advocate intimation and assertion the matter was still pending. Second blame. Now, my lord, paragraph 11, my lord, upon coming to learn about such order of dismissal, the petition applicant requested the erstwhile advocate on record to obtain certified copies of the order and apply for restoration. Accordingly, the draft restoration application was prepared and shared by the advocate on and about 24th May 2024. Thereafter, the Honorable Court was closed for summer vacation and reopened on so-and-so date. After, despite the best efforts of the petitioner, the said restoration applications could not be finalized and filed before the Honorable Court due to medical exigencies of learned erstwhile advocate. Again, blame number 3. He was unwell. Under such compelling circumstances and after waiting till 18 June 2024, the petitioner's applicants obtained a no objection and or change from the erstwhile advocate on 19 June 2024 and engaged appointed the present advocate on record. All cost papers were then provided to the prisoner so-and-so. So blame 1, blame 2, blame 3. So this poor gentleman has been fully put in the dock for the sake of condoning the delay, my lord, of 855 days. And there is also a very, my lord, very recent judgment which my learned sister has brought on, or I don't know, the 2024 judgment. Guru Swami, my lord, that today I am not equipped with that judgment. It's a very, lordship, very recent judgment. And my lord, Honorable Supreme Court has been given a cautionary note that it should not be readily Guru Swami or something like that. It should not be, yes, it's a very, LRTT is very much citing this judgment in each of the judgment, lordship. So I shall place, if your lordship, my lord, today I can't, my lord, but there is very recent judgment. So, my lord, these are the my respectful submissions, lordship.
My lord, may I reply to this?
Yes.
My lord, first of all, starting with what my learned friend just said, the three blames on my advocate on record. We have not blamed him for any negligence. We have said he was unwell. Paragraph 9, in COVID, that was the second phase, was at a peak in August. He was unwell. He missed the matter. So it only came to his notice when we made enquiries. They were also a big company, my lord. When someone made enquiries, only it came to his notice. And then he couldn't continue because of his medical exigencies. And we have not put the blame on his head, as it was said, and executed him. Well, there's no ill feeling about that. It happens all the time. That is number one, my lord. And I would have placed paragraph 9, 10, and 11 itself to say that that is sufficient cause that these things happen. Now, the other thing is the two judgments my learned friend cited. Luckily, I don't have to distinguish it too much because, my lord, we have got a judgment passed by my lord. My lord sees the Ashish Kumar Ghosh versus Ashanath Ghosh. Now, your lordship has had the occasion to consider the cases my learned friend for the respondent number 1 cited, Rajneesh Kumar. If my lord sees this, the facts are nearly identical. Again, during COVID, my lord, the application had been dismissed for default. And an important thing is, and when our application was dismissed for default, my learned friends also never appeared. It happened accidentally. That time it was online and it happened. If my lord comes to page 3, at the bottom, learned counsel for respondent number 1 submitted that the tendency of the litigant to place the liability of his non-diligency upon the learned advocate of the court has been criticized. Well, we have not tried to blame him for anything. He was unwell. He did not inform us. Then this Rajneesh Kumar case was cited, and another 2024, I don't know if this is what my learned friend was referring to, was cited. Now, your lordship turns the page 4. Exactly the portion that my learned friend cited, paragraph 10, has been considered by my lord. And Pashupati Nath also has been considered, where there was drastically, they were blaming the lawyers. Now, if my lord comes to page 7, the findings. My learned friends also cited another judgment today, the limitation judgment, where it says that, yes, liberally it should be construed, but it's my lord's discretion. Page 7, my lord has got of your lordship's decision. Page 7 at the bottom. Perused observation passed by the Honorable Supreme Court in several judgments. This application under Section 5, Section 3 of the Limitation Act has provided a suit or appeal has to be filed within a specific period as enumerated. Section 5 has given liberty to apply before the court if he can demonstrate some showing of sufficient cause, for which he presented the approach to court. Law of limitation is enumerated under Section 5, has been dealt with in the Supreme Court judgments. Well, these judgments, your lordships, considered the earlier judgment, 1987-2, wherein it was observed that the Honorable Supreme Court that a liberal approach has to be taken in dealing with sufficient cause of the litigant. In Rajneesh Kumar, the Honorable Supreme Court is of the view that placing the blame on the learned advocate for condonation cannot be the sole cause of condonation. It is specifically observed that the litigant who is not diligent cannot be called to get equity under Section 5. Then your lordship considers the facts of that case. Then the important decision is Ashok Kumar, which your lordship relied on. And at page 9, the observation of the Supreme Court in Ashok Kumar has proved that the appellant should not suffer due to laches of the advocate. In the present case, it appears to be delay occurred due to the conduct of the erstwhile advocate as well as pandemic situation. Here is due to the ill health and the pandemic situation. It is well known that COVID pandemic had spread throughout the country for 2 years, as is well known to the fact that the missing diary of a learned advocate may be due to multiple reasons. So he just missed the matter, my lord, and he was after pandemic when we slowly got back into work. It's escaped their notice. Still, specific queries were made, as we've said in paragraphs 9, 10, and 11. Then your lordship has considered this and taken the liberal view. I would beseech my lord to take a similar view, put us on terms if necessary, and a little bit on the merits. I can, of course, also argue on the merits, but a little bit only, I would say. What had happened was they had allotted some land to the petitioner, out of which only a portion was given. And I am occupying that land. And the rest of it, though I've paid for the 700 acres, I received only 500 acres, and the project could not be begun. It was we were to make a refinery and a thermal plant. But that is on merits. It is not as if the state is going to, there's some vested right that has come to the state that they will oppose this application and it will go unheard. We are challenging our termination. And on the ground that we have paid for the land of more than 700 acres, but we have received only 500 and we were promised 2,500. But that is on the merits, my lord. Your lordship will hear that there is no interim order. So my learned friends are not, clients are not prejudiced in any manner.
Your lordship, with the deepest of respect, your lordship.
Yes. That's all.
Let us. Yes, ma'am. This is what more can I say? We are in your lordship's hands in the interest of justice. My lord, the sufficient cause has been shown. There is no reason for us to delay this writ petition or come back later. And the third case my learned friend cited was on a stale claim. Our claim is not stale. We filed the writ petition immediately in 2007, as soon as the termination letter came. So that third case that my learned friend cited, my lord, I think it was 76 Supreme Court. I'm sorry, I didn't get to write it. Yes.
76. So,
yes.
Sir, 71 to SCC 860.
Yes. So that decision, my lord, said that the action for a defaulting litigant was that he slept over his rights and then came to court late. But here is the writ petition was filed in absolutely the normal time as soon as we got the termination letter. Thereafter, my lord, for whatever reasons, it was not been heard. But then also we are not taking advantage of any interim order, etc. So the COVID was definitely there. It's not the length of the delay, but it's the quality, my lord. If we didn't know, there was no way of improving it. And my learned friends, advocates, clients, advocates were also not there on that day. No one appeared. It had appeared in the warning list. Paragraph 9, my lord, I believe the explanation is given. And there is no question of blame, as it were. It was the cause, rather, the illness and his ill health.
Your lordship.
The judgment period which I was referring to, I could get it in my device. The January, actually, the Guru Swami judgment. I'm just giving the citation.
Yes, ma'am. Thank you.
এটা হচ্ছে H. Guru Swami versus A. Krishnaiya since deceased 8th January 2025. Lordship got the device. Miller, paragraph 13 kindly sees lordship. We are at our wits' end to understand why the High Court overlooked all the aforesaid aspects. What was the good reason for the High Court to ignore all this? Time and again, the Supreme Court has reminded the district judiciary as well as the High Courts that the concepts such as liberal approach, justice-oriented approach, substantial justice should not be employed to frustrate or jettison the substantial law of limitation. We are, para 14, we are constrained to observe that a High Court has exhibited complete absence of judicial conscience and restraints, which a judge is expected to maintain while adjudicating a lease between the parties. Para 15, the rules of limitation are not meant to destroy the rights of parties. They are meant to see what the parties do not resort to dilatory tactics, but seek their remedy promptly. The length of the delay is definitely a relevant matter.
It is paragraph?
Millard, I am reading from 13, 14,
Yes.
15. Now I am in 16.
Okay.
Now I am in 16, Lordship. The length of delay is definitely a relevant matter which the court must take into consideration while considering whether the delay should be condoned or not. From the tenor of the approach of the respondents herein, it appears that they want to fix their own period of limitation for the purpose of instituting the proceedings for which law has prescribed a period of limitation. Once it is held that a party has lost his right to have the matter considered on merits because of his own inaction for a long, it cannot be presumed to be non-deliberate delay. And in such circumstances of the case, he cannot be heard to plead that the substantial justice deserves to be preferred as against the technical considerations. While considering the plea for condonation of delay, the court must not start with the merits of the main matter. The court owes a duty to first ascertain the bona fides of the explanation offered by the party seeking condonation. It is only if the sufficient cause assigned by the litigant and the opposition of the other side is equally balanced that a court may bring into aid the merits of matter for the purpose of condoning the delay. We are now para 17. We are of the view the question of limitation is not merely a technical consideration. The rules of limitation are based on the principles of sound public policy and principles of equity. No court should keep the sword or Damocles hanging over the head of a litigant for an indefinite period of time. So 13 to 17, I'd like to rely upon this judgment. May a copy be taken out from your lordship?
I'll take.
Lordship, this is the one I was, sir, patient. Sir,
with the deepest of respects, the judgment which was placed by them, your lordship kindly considers the
Reply against reply.
just one
Yes.
point, your lordship, that the writ petition was dismissed in the year November 11, 2019, your lordship, and COVID started from March 2020. Your
I know
lordship.
that. I know that. I have read the judgment already. This is my judgment. I know.
21.
This in this our case, your lordship, there is even a delay of more than a year after COVID, your lordship. Kindly considers that, your lordship. Grateful.
Well, I'm not replying, but only one comment, if I may make. Your lordship's task is very difficult because my learned friend just read out the Supreme Court where it said the length of delay is not material. And your lordship has quoted Supreme Court 2024. I'm reading it. It is not the length of delay that would be required to be considered. It is the cause of delay that is to be. So it's the onus is on my lord. There is no straight fixed principle. It is only the question of whether the bona fides is correct. The bona fides test is correct. Well, there is nothing for us to gain. That is why I said the bit of the merit, which my learned friend cited the principle. They said that if once the cause has been explained, a merit can also be looked into when exercising my lord's discretion.
Okay.
We are in my lord's hands, and if your lordship allows us, then we any day, if the writ is fixed along with this also, or your lordship decides this, and then we will, if we are successful, then we'll hear the. Each case depends on its facts. That's.
Please take down.
My lord, may I be excused? I'm in
Okay.
some difficulty today. I'm grateful.
Can 1 of 2024? Can 2 of 2024? Can 1 of 2024? Next paragraph is an application for restoration of writ petition being WPA 23409 of 2007, which was dismissed for default on 11th of August 2021. Full stop. Next paragraph, can 2 of 2024 is an application under section 5 of Limitation Act for condonation of delay of 855 days in preferring the application being can 1 of 2024. Full stop. Headline करूं can 2 of 2024.
अभी ये थोड़ी पूछ रहा है.
Decision application for condonation of delay filed under Section 5 of Limitation Act on the ground that the petitioner herein was prevented by sufficient cause for which they could not appear before the court on 11th of August 2021 when it was called on for hearing. Moreover, it is the ground for the it is the application for the application of the petitioner that the petitioners were prevented due to laches and inaction of the erstwhile advocate upon whom they impose their entire reliance to conduct the case before this court. For better appreciation of the matter, the impugn order of dismissal required to be set out. Order number, order dated 11/8/2021. Set out court. হয়েছে? In the application being Can 2 of 2024, the petitioner has demonstrated the sufficient reason as follows. A, functioning of the High Court was not regular till regular from 21st February. No, till regular till 28th February 2022, which period includes the whole 2020 and 2021, comma, during 2021, second wave of COVID pandemic had created havoc and entire court proceedings were hampered. Thus, the petitioner were not in regular contact with petitioner erstwhile advocate. B, in the second week of May 2024, while the accounts team of the petitioner, accounts team, A capital, accounts team of the petitioner requested erstwhile advocate regarding the status of the matter, first of all, they came to know about the order of dismissal on 16th of May 2024. Third, C, erstwhile learned advocate intimated the petitioner that during COVID pandemic, the matter had come up for hearing on 11th August 2021 before Honorable Justice, before the Honorable Coordinate Bench, and learned advocate was unwell and completely missed the list Number D, the said erstwhile learned advocate was unaware about the said order of dismissal with a genuine impression that the matter was still pending. He came to know about the pending, and for the first time, learned erstwhile advocate came to know about the order of dismissal on 16th of May 2024. Petitioner instructed the learned petitioner requested the learned erstwhile advocate to F লিখছো F লিখো
Lord, may I have my lords kindly?
petitioner erstwhile কি বললাম বলো erstwhile advocate to obtain a certified copy of the order and apply for restoration, but due to the illness of the erstwhile advocate, the instant application for restoration could not file before summer vacation for the year 2024. Thereafter, next para মানে G হবে. Thereafter, they obtained no objection from the erstwhile advocate on 29th of June 2024 and filed the instant application for restoration to the learned present advocate on 2nd of July 2020. Next, petitioners were diligent to do with the writ petitions, but impose their entire reliance upon the learned erstwhile advocate. Due to the laches of the learned erstwhile advocate, the matter was dismissed for default. And the instant application was filed about 1056 days delay. Good stuff. Learned senior advocate, Mr. Dhruvo Ghosh, appear virtually, submits that the petitioners were always diligent to do the matter, and but due to the conduct of the erstwhile advocate, the matter was dismissed for default. The petitioner also could not file the restoration application within time, as the COVID pandemic was there at the time. Thus, they were in an impression that the matter was pending. It is further argued on behalf of the learned counsel for the petitioner that the there are sufficient merit in the instant matter to be considered. So at this juncture, the entire writ petition cannot be. Entire writ petition is required to be restored. He also placed his reliance upon a judgment, upon an order dated 10th of January 2025, passed by this court in SA 48 of 2018, stroke Can 3 of 2023, within bracket Ashish Kumar Ghosh versus Anant Ghosh. Ashish Kumar Ghosh and others versus Anant Ghosh, wherein similar issue was raised before this court regarding negligence of erstwhile advocate, and this court, after dealing with the entire matter and also following the observation of Honorable Supreme Court in collector, land acquisition, Anantnag versus Katiji, Catiji, within bracket 1987 2 SCC 107, and also following the observation of Honorable Supreme Court in Ashok Kumar versus New India Assurance Company Limited, within bracket 2024 1 SCC 357, as well as in Mool Chandra, MLL, Mool Chandra versus Union of India and another 2024 SCC online SC 1878, comma, this court has taken lenient view when a matter was dismissed for default due to conduct of erstwhile advocate as well as the COVID pandemic situation, and restored the writ petition by condoning a long delay. Full stop. Learned counsel for the petitioner, Mr. Ghosh, further argued that the acceptance of sufficient reason as stated by the petitioner is a discretion of this court. The court must do justice to the petitioner, and shall not consider the period of delay, but only shall consider whether there should be a necessary, there should be a when there is a merit in the instant matter to dispose of. Full stop. Under the above, no, he further submits that the instant application for restoration, instant application for limitation act being Can 2 of 2025 is required to be allowed along with application for restoration, and the writ petition be restored to its original file and number by setting aside, by recalling the order dated 11th August 2021. Full stop. Learned counsel appearing on behalf of respondent number 123 raised strong objection and submits that the Honorable Supreme Court has deprecated the practice of litigant to impose all blame upon conducting advocate. He submits that in Rajneesh Kumar and another versus Ved Prakash, the Honorable Supreme Court has categorically observed that the petitioner's non-diligence should not be placed upon the learned lawyer who conducted the case. He placed reliance upon paragraph 10 of Rajneesh Kumar and another versus Ved Prakash. Paragraph 10 ta set out করবে. He also placed reliance upon decision of Honorable Supreme Court in Pathpati Subba Reddy within bracket died versus Special Duty Collector within bracket LA, reported in 2024 SCC Online SC 513 paragraph 26 set of court. He also relied another decision of Honorable Supreme Court in Messrs Bharat Barrel and Drum MFG Company Limited and another versus Employees State Insurance Corporation, reported in 2071 2 SCC 860. Full stop down. Relevant portion of paragraph 7 of the said judgment is quoted below. A2. Learned counsel for the petition next paragraph. Petition number 3 further submits that the facts and circumstances of Ashish Kumar Ghosh is totally different. Full stop. In the case of Ashish Kumar Ghosh, the writ petition was dismissed for default just prior to the COVID pandemic. Application for restoration was filed with a condonation of delay in Ashish Kumar Ghosh after 1145 days delay. This court has specifically observed in Ashish Kumar Ghosh that the delay is not caused solely due to the laches of learned advocate, but it was due to the COVID pandemic also. Thus, this court has taken the lenient view. She submits that in this case, the petitioners were not at all diligent to do with this matter. The impugned order dated 11th of August 2021 made it clear that the writ petition was pending since 2007. Moreover, it was appearing in the warning list for a considerable period of time. Full stop. He further submits that the petitioners were well aware about the running of warning list, but they did not take steps. Thus, the order of dismissal is justified. He further submits that in view of the decision of Honorable Apex Court in Rajneesh Kumar and another, Supra, the instant application being Can 1 and Can 2 of 2024, Can 1 of 2024 and Can 2 of 2024 cannot be allowed. Full stop. The only reason for delay is assigned to be the negligence on the part of the learned advocate. Full stop. Which was deprecated by the Honorable Supreme Court in Rajneesh Kumar. The Honorable Supreme Court, he further submits the Honorable Supreme Court has declared the law to that effect. Thus, the instant applications are required to be dismissed. Full stop. Next paragraph. Sheikh Muhammad Ghalib, learned counsel, appearing on behalf of the state, submits that the instant applications being Can 1 of 2024 as well as Can 2 of 2024 is not required to be considered as the grounds stated in the applications itself are not acceptable at all. Full stop. He further submits that the Honorable Supreme Court in H. Guruswamy and others versus A. Krishna Iyer, A. Krishnaaiah, since deceased by LRS, within bracket civil appeal number 317 of 2025, bracket close, has observed that the rule of limitation as enumerated under section 3 as well as section 5 of Limitation Act are not meant to destroy the rights of the parties. They are meant to see that the parties do not resort to dilatory tactics but seek their remedy promptly. Dilatory tactics, TICS, but seek their remedy promptly. The Honorable Supreme Court has specifically observed that the question of limitation is not merely a technical consideration. The rule of limitation are based on principle of sound public policy and principle of equity. Full stop. Learned counsel for the Mr. Ghalib has referred paragraph 13 to 17 of the said observation of Honorable Apex Court. Next paragraph. Learned senior counsel Mr. Dhruva Ghosh, in reply, has submits that the entire consideration and discretion of this court is on the basis of due justice to the petitioner. The petitioner has a good case before this court to be decided. The suit was dismissed for the writ petition was dismissed for default only due to the laches of the learned counsel and for COVID pandemic situation. Thus, the instant writ petition is required to be revived. Heard the learned counsels peruse the order passed by the Honorable Coordinate Bench on 11th of August 2021. At the time of disposing of the writ petition for default, the Honorable Coordinate Bench has observed that since the writ petition was pending for from year 2007, and the matter had appearing in the warning list for considerable period of time, but the petitioner could not appear or take steps. Thus, the matter was dismissed for default. The ground stated in the application being Can 2 of 2025, if dissect properly, it appears that the petitioner, being a company, has entrusted a learned advocate to conduct the writ petition before this court. In paragraph 8 in paragraph 8 to paragraph 11, paragraph 11, they have disclosed the ground, how they ground as to why they filed the application for restoration in delay. The ground appears to be solely due to the laches of the learned counsel engaged by them to conduct the matter. First of all, the petitioner stated the ground that the learned counsel has missed the diary due to COVID pandemic and could not appear before the court when the matter was called on for hearing on 11th August 2020. When the matter was called on for hearing on 11th of August 2021. Full stop. Fact suggests that the matter was not fixed on 11th of August 2021, but it was running in the work warning list before the bench for a quite few days. There is no explanation by the petitioner why the petitioner as well as the learned erstwhile advocate of the petitioner could not take proper steps in spite of running the matter in warning list. I make it clear that the warning list is prepared according to the appellate side rule of this court, wherein a bench when put a matter in warning list, it is the duty to the petitioner or the person engaged therein on behalf of the petitioner to take proper steps. This is a warning to the petitioner or the person engaged therein that the matter shall take up on the fixed date. Full stop. In the inter application being can 2 of 2025 or can 1 of 2024. 2 of 2024 or can 1 of 2024. There are no explanation how the learned erstwhile advocate has missed the warning list of the court. Full stop. It further appears from the ground that the learned advocate of the learned erstwhile advocate of the petitioner as well as the petitioner's accounts team first of all came to know about the order on 16th of May 2024. 16th of May 2020. Full stop. However, they could not possibly file the application on or before 2nd July 2024 due to the reasons that the learned erstwhile advocate was ill at that point of time. Full stop. It appears that the grounds mentioned in the application being can 2 of 2024 is only blaming upon the learned erstwhile advocate who conducted the matter before this court. The petitioner has not disclosed any reason or explanation why since the year 2017 till the date of disposal of the writ petition on 11th of August 2021. They were not diligent, or they have not taken any steps. Moreover, the law as declared by the Honorable Apex Court in Rajneesh Kumar and another in Ved Prakash has categorically deprecated the practice of the litigant to blame their lawyers' negligence and carelessness in attending the proceeding before the court. I make it clear that this court has not apprised by application or any pleading of the application or statement that how the petitioner, being a company solely dependent upon the learned advocate to do the matter since 2007 to 2021. Full stop. In Patpati Subba Reddy Supra, the Honorable Apex Court has set out some guideline in paragraph 26 and has specifically made it clear that law of limitation is based upon public policy. Clear that the law of limitation is based upon public policy, that there should be an end of litigation by forfeiting the right to remedy rather than the right itself. Forfeiting the right to remedy rather than right itself. The Honorable Supreme Court has also clearly guided that merit of a case are not required to be considered in condonation of dealing. Full stop. In Messrs. Bharat Barrel and Ram MGF Supra, the Honorable Supreme Court has specifically enumerated that the object of statutes of limitation is to compel a person to exercise his right of action within a reasonable time, as also to discourage and suppress stale, fake or fraudulent claim. Full stop. Next paragraph. In collector, next paragraph. In collector, land acquisition, Anantnag, Honorable Supreme Court has guided that in deciding sufficient cause in an application under Section 5 of Limitation Act, the court should take a liberal approach. The court should adopt a liberal approach. In the same observation, the Honorable Apex Court has also guided that the court must consider that a litigation has to be disposed of on merit. Full stop. Considering the entire circumstances and considering the facts narrated herein, it appears to me that the present petitioner has shown the cause in application being can 1 of 2024 as can 2 of 2024 is only negligence and laches on the part of the advocate, the part of the erstwhile advocate. I can understand, full stop, I can understand that learned counsel, learned advocate of this court may miss diary on numerous reasons. But at the same time, when a matter is running in warning list of a court, such reasons for missing the diary is not at all acceptable. I also make it clear that the honorable the instant application was filed only upon blaming upon the learned erstwhile advocate. The honorable apex court in Rajneesh Kumar and another has declared the law that an application for condonation of delay cannot be accepted while it was only blamed upon the conducting advocate. At this juncture, I think it necessary to hold that. I hold that. No, at this juncture, it is my clear view that as this application was filed only placing blame upon the learned erstwhile advocate for the petitioner, who according to them, were not diligent in dealing with this matter, and as the petitioner has not assigned any reasons or diligence on their part to conduct the writ petition since 2017. Thus, I find no justifiable ground to accept the cause as shown in the application being can 2 of 2024 be a sufficient cause. Thus, the application under section 5 of Limitation Act being can 2 of 2024 appears to me not meritorious, and the same is hereby dismissed. Full stop. Next paragraph. Consequently, the application for restoration of order application for restoration of order dated 11th of August 2021 is hereby also dismissed. Accordingly, can 1 as well as can 2 of 2024 are dismissed and disposed of.
Grateful, Your Lordships.
এটা দিন। Call next matter.
Grateful, Your Lordship.
I am for the petitioner, my lord. My senior is sick and she is suffering from
What are the
fever.
10 applications for restoration?
Yes.
Lord, I am appealing for the private respondents. My lord, we have not been served with copies of the application.
Why not serve?
I will.
You serve
my
today.
senior. Okay, ma'am.
Both the applications, can 1, can 2, and can 3.
There are 3 applications, I believe, my lord, in the list.
1, 2, and 3. Yes. What is the application being can 1?
Well, from the order sheet, it would reveal that the matter was dismissed for default. And while the restoration application was pending, it was again dismissed for default. So applications should be for the said purpose.
Can 1 is an application for restoration.
Yes, my lord.
It was dismissed.
That is what I submitted, my lord. While Can 1 was pending, the matter was dismissed once again. That restoration application was dismissed for
Now,
default.
writ petition was dismissed earlier.
Yes.
Thereafter, Can 1
Can
filed.
1 was
It
dismissed
was
for
also
default.
dismissed for default.
Yes, my lord.
Now they have preferred Can 2 and Can 3.
This is restoration of restoration. 2 and 3.
Restoration of restoration.
Maybe there is
Can 1
contradiction.
of 2027. Yes, who are you? You are appearing for the petitioner.
Yes, my lord.
Why such long restorations? 2 restorations are there.
My lord, my senior is sick, my lord. Next hearing, my lord, my senior will.
It is running in the list. What you want? You have not served the copy to them.
I will serve, my lord.
When you will serve? It is today is running in the list. Do you want I dismiss the matter today again?
No, my lord.
Then why not serving? Please take down. Petitioner is directed to serve the application being Can 2 on Can 2 of 2025 and Can 3 of 2025 upon the upon the all respondents and file an affidavit of service.
Well, Can 1 as well. We have not received Can 1.
Can 1 was dismissed.
Yes, my lord.
It was not revived. Let it
All right.
revive. Thereafter, I
My
will
lord.
direct to serve.
My lord.
Can number 3, 2025 upon the respondents and file an affidavit of service on the returnable date. Let the matter appear in the list on 28th.
My lord, can it be 29th instead of 28th?
Then it
My
will
lord,
appear on it will appear on 4th of September.
my lord, in grateful manner.
Next.
And I'm from the petitioner, my lord. There are 2 cans, my lord. One is for restoration, one is for, my lord, section 5 application. My lord, the matter was dismissed on, my lord, (22nd February 2023), and my lord, the
When you file the can?
restoration was filed, my lord, on 20th July 2023. But there's-
February and July.
July. There's a 120 days delay, my lord.
What is the matter? What is the merit?
This matter relates to, my lord, compensation for acquisition, my lord.
Compensation for acquisition?
Yes, my lord.
Is there any acquisition?
Yes, it's
over your land?
for my land.
Have you received the notice?
No, nothing has been received, my
Who
lord.
are you? Subsequent purchaser?
No, no, my lord. I am the original owner. Actually, we are the original owner.
You are the original owner?
The petitioners, my lord. There are
Petitioners?
so many petitions. Five petitioners are there, my lord.
The predecessor of interest of the petitioner, petitioner's father was the original
owner.
Chittaranjan Ghodai.
The allegation is this, my lord, in the 2009, their land has been, my lord, utilized for the purpose of construction of dam.
Embankment.
By the
Yes, yes.
For the dam, my lord, by the respondent number 6, irrigation department.
Yes.
They, along with the, my lord, the other villagers, made representation before the authority. That is pending.
That is pending.
That is pending. No decision has been taken. But my contention is this, my lord. This allegation is totally baseless, my lord. If they, my lord, came to know the land has been utilized in the 2009, why they have filed this application in the year 2007? And they have stated, my lord, they have made representation along with the villagers. No such signature of the petitioners in the representations. Your lordship kindly come to, my lord. 3 representations are there. And signatures are same, my lord. It is the photostat copy of the application, my lord. All signatures. First signature application, my lord. 19 September page 23.
Yes.
Khudiram Mondal, Dhananjay Patra, Session Sir.
Yes.
Next vigilant, Sir. No signature of the petitioners. Then we run next.
So who is the petitioner here?
That is just that copy. Next, my lord, representation dated, my lord, 21st September 2000. Similar signatures, my lord. How it is possible, my lord? Then we run last, my lord, representation. That is in the 2002. Same signatures. Pages are, my lord, photostat, and it has been
My lord,
enclosed.
our representation as at page 31.
No, no.
Page
Your
31.
representation is there.
Yes. We have, my
That
lord,
is the advocate's
through,
letter.
yes,
That cannot be
through,
treated as an
through my lord,
representation.
our learned advocate, we have sent a notice on 30 June
Without any
2017, my lord.
Advocate's letter. That cannot be treated as a representation.
Yes.
That is also in the year
2017. my lord. 17.
After 8 years. No
After,
explanation.
as and when we came to know about the compensation proceeding, my lord, we have filed.
To know in the year 2009.
तो बोलते थे never.
Pragati Ghodai.
Yes, my lord.
You have not made any representation. You have only filed a advocate's letter to the district collector.
Yes, my lord. Through our learned advocate, my lord. That can be considered, my
No,
lord.
that cannot be treated as a representation.
You have to make a detailed representation with your document.
Very well, my lord. My lord, kindly grant me liberty, my lord, so that, my lord, this writ petition can be treated as, my lord,
no,
representation.
No, writ petition. You made a fresh representation. Yes. I am disposing of the writ petition. So what is your plot?
My lord, my plot is
2624.
2624.
So where is the document that it was acquired? Have you any file?
No document, my lord. We have heard, we have came to know that this.
How you came to know?
My lord, this landed property, we don't have any details, my lord. That is the difficulty. That is the difficulty, my lord.
You can say so. Your plot, you have filed.
But my plot has been acquired.
So how you came to know?
But I have not served with the notice. Kindly consider that, my lord. I have not served with the notice.
No. You just.
I don't have any details, my lord.
You just taking otherwise. You are saying
no,
otherwise.
My lord, may kindly.
Today.
Yes, ma'am.
If some property of your some property was gone to Khatiya number 1, there must have some record.
No, my lord. After Khatiya number 1, my lord, there is a record. But, my lord, when the land is acquired, I have not been served with any notice.
So
I don't have the details, my lord.
Where is the information?
I don't
Where
have.
is the credible information that your some portion of plot has been acquired?
My lord, kindly come at page 33.
But that is the advocate's letter.
How bolte thi? 34, my lord. 34.
Utilized was taken over.
Page number 34 in the notice, my lord.
No. Notice I have understand. Notice
from
other
land users, my lord, we have came to learn about the, my lord, acquisition proceeding.
So you have heard from the others. And there is no credible value of your evidence. Hearsay only.
And the earlier occasion,
hearsay you appear before this court.
My lord, an earlier occasion, my lord, another writ petition. Another writ petition was filed, and that was allowed, my lord. Writ petition number 17298 W of 2013, my lord.
Allowed of what? Allowed means
on the same mauja, my lord. This on the self-same. Yes, on the self-same, my lord, acquisition proceeding. On the self-same acquisition, my lord.
Show me a single paper that your plot was acquired. Not by hearsay.
Very well, my lord. Kindly, my lord, grant me my lord, 1 day's accommodation, my lord. I will come with the instruction.
Why today 1 day's accommodation? What
only 1 day's accommodation.
You cannot revive, you cannot strengthen your writ petition by that. You have nothing placed.
My lord, I'm only praying for 1 day's accommodation, my lord, to, my lord, satisfy your lordship. Only 1 day's accommodation.
You file a detailed representation with document to the authority. I am disposing of the writ petition.
Very well, my lord.
Please take down. Can 1 of 2023, can 2 of 2023. Instant writ petition. Now, having heard the learned counsel for the party, instant writ petition B and the same is hereby restored by condonation of delay to its origin file and number. Full stop. The instant writ petition is taken up for hearing in presence of learned counsel for the petitioner as well as the learned counsel appearing on behalf of the state. Full stop. Petitioners are the owners. Petitioner are the legal heirs of one Chittaranjan Ghodui, who was the owner of plot number 2624 under Mauja Horipur in Khatiyar number 36 Horipur within district
Mauja Horipur district Namkhana.
District within PS Namkhana.
PS Namkhana.
District South 24 Parganas. It is the contention of the petitioner that some portion, after demise of Chittaranjan Ghodui, the present petitioners, being the legal heirs, are possessing the plot by way of inheritance. Full stop. It is the contention of the petitioner that the different plots of same Mauja Horipur was acquired by the state for construction of dam, including some portion of plot number 2624. Full stop. He submits that the villagers had made representation to the concerned authority several times, but the authority concerned has not responded any of their representations. The petitioners also filed a detailed representation through their learned advocate to the district magistrate and collector, South 24 Parganas, on 30th of June 2017, contending inter alia that some portion of their plot of land has acquired without providing any compensation. Full stop. Learned counsel appearing on behalf of the state refuted the contention and submits that the petitioner has never made any representation to the authority, but has only issued an advocate letter. He further submits that no evidence was placed in this writ petition to show that any portion of the land of the petitioner was acquired. Having heard the learned counsel for the parties, also considering the annexures as well as the pleading of the instant writ petition, it appears that though the present petitioner has placed a record of right in respect of plot number 2624 under Mauja Horipur, but they have not placed any document to show that any portion of such land was acquired by the state for the construction of dam. However, the petitioner approached this court without any proper evidence, but they have every opportunity to ventilate their grievances to the authority concerned. Under the above observation, the instant writ petition is disposed of with a direction to the petitioner to approach the
district magistrate.
Learned approach the
District magistrate.
collector. Collector come district magistrate, South 24 Parganas.
Respondent number 3, special land acquisition.
Okay, ठीक. The কি বলো?
Respondent number 3, special land acquisition.
না, approach the special land acquisition officer, comma, South 24 Parganas, being respondent number 3. কি বললাম বা? হ্যাঁ, with a detailed representation, with a detailed representation coupled with sufficient document, so that the respondent number 3 may deal with the grievances of the petitioner. Full stop. The petitioner is directed to make the representation to respondent number 3 within 3 weeks from the date of passing of this order. Comma, semicolon. The respondent number 3 shall dispose of the representation of the petitioner within 6 weeks from the date of receiving such representation, and shall intimate the decision. No, কি বললাম? And কি বললাম? না, and shall and থেকে কাটো। কি বললাম? After giving a reasonable opportunity of being heard to the petitioner. The decision of the authority shall be communicated to the petitioner within 2 weeks thereafter. Full stop. I make it clear that this court has not entered into the merit of this matter. The respondent number 3 shall independently take a decision on the representation of the petitioner without being influenced by any observation of this court. Since no affidavit have been exchanged between the parties, the allegation made in the writ petition shall be deemed to have been not admitted. Instant writ petition along with connected applications, if any, are disposed of.
My lord, the affidavit of service may be taken.
Affidavit of service. Next.
I'm grateful, ma'am.
Ajay.
But I am appearing for the state response.
And I appear for the petitioner. Yes, Mr. Talukdar was advancing his argument, my lord.
Yes, Mr. Talukdar was there. Yes.
May I leave for
জানি 33-এ ছিল
চলবে না
একটু
I do not know.
Only I cannot say, my lord. Perhaps it will take time.
However,
But
I will take up this matter continue after 2 p.m. No issue.
my lord, I may pray in advance to allow me couple of minutes because I have a matter in court number 26 that is approaching. If called, my lord, for a couple of minutes, I will take it.
Very good. You proceed.
My lord, on the last occasion, my lord, I took the point on affirmation of affidavit. My lord may kindly recall that this affidavit was not, this writ petition was not properly verified. It is affirmed by constituted attorney whether there is no averment made in the writ petition as to such authorization. There is no such pleadings. And the constituted attorney, if you lordship sees at page 38 of the writ petition, he affirms, he verifies the statements made in paragraph number 1 to all. My lord said on the last occasion, in my copy there is no mention, 1 to 30 or 33, true to his knowledge. So as a constituted attorney, how it came to his knowledge, that averment lordship will not find in the writ petition. So the affirmation, the writ petition itself is defective one, and no cognizance can be taken by the Honorable Court, my lord, on the statements made in the writ petition. My lord, in that regard, my lord, the rules regarding affirmation, my lord will see. Okay.
Appellate side rule.
Appellate side rules. If your lordship sees the affidavit, this is if your lordship sees the general rules for applications and affidavits, which is the principle is applicable to the writ petition also. Chapter 4.
Chapter 4.
Chapter 4. The affidavit deals, my lord, rules 22 onwards.
Rules 22 onwards.
Yes.
Yes.
The very relevant is 28. This ought to have been followed.
Yes.
So this has not been followed here.
Rule 28.
28 of chapter 4. It starts with, my lord, when a particular fact is not within. So here that averment was necessary. So in my respectful submission, because my lord, court will be granting relief on a petition before it. If that petition, the rules prescribes a format for approaching the Honorable Court in a particular form, in a particular manner, that is why the rules are framed. That requires to be followed. If that is not done, the application to be treated as defective and no relief should be granted on that petition. And then, my lord, I have on the last occasion, just to remind your lordships, that I have also referred to the prayers made, that also that would appear to be vague one.
Doesn't contain specific LA case number.
Yes.
That is
What
why
is
the
under
prayers are vague and independent.
He has said many things, argued many things, but the court cannot, my lord knows, this is the settled principles of law, and there are catena of judgments on that. The court cannot travel beyond the scope of the writ petition, beyond the scope of the pleadings. So here on the face of it, my lord, the prayers as also the affirmation, the verification, which is most important. Because my lord will be deciding a fact and passing an order. My lord will be applying law on a fact stated in the, pleaded in the petition. So the facts pleaded in the writ petitions, my lord, in my respectful submission, cannot be looked into because of improper verification. Rules were not followed. Prayers were not couched in the manner the petition was argued, claiming relief. This is, my lord, may seem to be a technical one, but it goes to the root. Before granting a relief, the court will first see that the application is in proper form. That is not.
Yes.
Now, my lord, this is on the point of this maintainability and all this. If you lordship, now the points comes in, my lord. Here, my lord has seen that particular plot, this 2456.
Total area 37 decimal.
37 decimal.
25 decimal were acquired.
Were acquired. Here, the petitioner, lordship kindly sees, he has averred in the writ petition that erstwhile owner was one Kanchanbala Devi.
Yes.
Kanchanbala Chakravarti. Then, my lord, in 2007,
transferred to Shambhu.
Transferred to Shambhu. In turn, Shambhu sold it to petitioner in 2011.
6th May 2011.
Yes. The petitioner, although this is my lord, this acquisition was done, my lord, sometimes in 1976-77. The LA case is of 1976-77. And that was duly concluded by passing award within time. And the erstwhile vendor, Kanchanbala, was one of the awards. And compensation was also, according to the state's affidavit, it was paid. Then this, after purchasing in 2011, this petitioner approached the authorities, state authorities as also the KMD authority, seeking information regarding that plot of land they have purchased. My lord, on their application, initially, my lord, if your lordship turns to page 90, this is stated at paragraph 10. If your lordship sees the paragraph 10, I'll be referring to the paragraph as also.
Paragraph 10 of writ petition.
Writ petition. 10A, it would be 10A. 10A. The petitioner, for the purpose of acquiring the present status of the purchased property, sought an information under the Right to Information Act, so and so had been acquired, so and so. The information excluding. So, P9, lordship will find at page 95. Lordship kindly straightway come to the document the petitioner is referring to.
Page 95.
Page 95. So here clearly states, my lord, this is updated. Lordship kindly take note of the date, that 13th February 2014, information was supplied to them. That an area of 0.25 acres, excluding the area covered by structure, was acquired.
Yes.
Then, my lord, lordship kindly come to that. Thereafter, the petitioner prayed before the authorities seeking NOC. Seeking NOC. Pursuant to his application, my lord, a joint demarcation was held, and it was found that the petitioner's claimed portion comes within the acquired area of KMDA. That lordship will find at page 104. I have stated in my earlier affidavit. I shall refer to this.
Which page?
My lord, page lordship is at 104.
104.
104. This is part of my affidavit. I shall, my lord, indicate that when
Affidavit of earlier petition.
Earlier petition. E. Lordship, kindly have a look. Para E. D says that he makes an application regarding the information supplied. On an application being made by the petitioner to the KMC for sanction of a building plan in RS the KMC requested the KMDA to inform it as to whether the petitioner's plot is falling outside the KMDA's acquired area or not. In response thereto, the answering respondent authority, being the KMDA, held a joint demarcation of the said plot, being RS plot number so and so in presence of the petitioner. Upon measurement, it was found that the petitioners possessed area in the said plot of land, being RS plot number 2456, falls within the acquired portion of the said plot under the East Calcutta area development project of KMDA, having been acquired in connection with LA case number LA2 of 2/105 of 76/77. This case plan so and so. That is also the annexed with. Lordship will find that R2 Lordship will find at page 125. The joint demarcation note will note and the site plan.
Joint demarcation bar koro, joint demarcation bar koro.
126 is the site plan. If you Lordship, may I read this? This is what, my lord, I have stated in paragraph
126.
125 is the report, joint demarcation report. May I read this?
Yes.
It's a handwritten. As per order of the joint secretary, so and so, dated, we, the undersigned, remain present on. My lord, my copy is not solely for demarcation of. Of Ganesh Adhikari's possessed area over RS plot number 2456, partly. Of course, partly out of 27,
not
25.
entire.
Yes, a structural part was excluded. It is found that the petitioner land on the said plot is fall in the acquired portion of
Case number such and such.
LA case number so and so of ECD. This plot not acquired
or an area 25.25 acres.
Oh, it would be a
excluding the area covered by structure.
Yes. The next paragraph, it is also mentioned here that the petitioner Ganesh Adhikari is present on spot on the scheduled date and time, but refused to sign. When it was found,
is the knowledge in the year 2017.
That is why I am referring to. So, my lord, the petitioners, Lordship will kindly take note of the purpose of referring to this fact is the date of knowledge. Even then, I shall come to that question later on. Even they came to know in February 2014 about the acquisition of the land in question. Even my lord, at the time of joint demarcation, the petitioner was made known to the fact. despite this knowledge, the petitioner has not chosen to come before this honorable court to challenge the acquisition proceeding on any ground. And this writ petition was filed, my lord, in 2020. Before filing this writ petition, now I come to that, wherefrom I read, my lord, the affidavit in opposition that was filed in connection with the writ petition filed by the petitioner in 2017, but not challenging, according to the petitioner, not challenging the acquisition proceeding. Here, it is according to the petitioner that against the municipal action, inaction, they filed that writ petition. In that writ petition, we have filed this affidavit disclosing about acquisition, because it is the, my lord, practice undertaken by two authorities, both are under the Urban Development and Municipal Affairs Department, KMC and KMDA both. Whenever an application for sanction is filed with the KMC, if it is within the KMA, that is Kolkata metropolitan area, it is incumbent upon the KMC to seek an observation from the KMDA whether land is affected by acquisition or not. It is not the individual concerned who has to approach the KMD. It is incumbent on the KMC itself. So the information which I shown to your lordship, that was asked for on asking by the KMC, we have furnished this information that out of 27 decimals of land, 25 is acquired. And later on, knowing all these facts, my lord, later on seeking NOC, we held joint demarcation. At the time of inspection, the petitioner was present. It was found that the portion he is claiming to have purchased falls within the acquired area of the KMD. Acquisition is not under challenge. Acquisition was not upset at the instance of anyone else. Acquisition stands. So what he has purchased, that is a vested property. Well, so by the alleged purchase, he has not acquired any right, title, interest in the land. When a land is vested, it is vested free from all encumbrances. The erstwhile owner loses title.
Yes.
Then, my lord, after this writ petition, the affidavits were exchanged. This writ petition, according to my information, got dismissed for default on 9th August 2018. He didn't say much about that writ petition.
Writ petition 13434 of W 2017, dismissed for default.
Just a minute, my lord. Just a minute.
First writ petition.
First writ petition. Yes, 13434.
W of 2017.
Yes, that was dismissed for default, but that fact was suppressed. That fact was not disclosed in this writ petition.
So this writ petition filed by the petitioner was challenging?
Here the peculiar, that is why the prayer I have referred to.
What was the prayer there?
Here, without referring to any acquisition proceeding number, what they have said, to cancel, quash, terminate, revoke, withdraw the purported acquisition or requisition.
In this writ petition?
In this writ petition.
No. What was the prayer in the earlier writ petition?
In the earlier writ petition, that was not disclosed. The writ petition, copy of the writ petition, I do not have that copy.
That is with regard to, my lord, sanction of the building plan.
Okay.
Municipal authorities did not, my lord, sanction the building plan.
That is why আমি সেটাই বলছি।
না না জজ সাহেব জিজ্ঞেস করতে বলে বলছি তুমি করছো আমি তো কোনো খারাপ কথা বলছি না।
And as your building plan was not sanctioned, you appear.
Yes, that I told my lord. You have heard that.
Okay, okay.
It was the query of his lordship. That's why.
But in response to that writ petition, we have disclosed the fact about acquisition. So it came to the knowledge of the petitioner. Had the petitioner been aggrieved by, he could have challenged specifically, but that he has not done. So he has annexed in this writ petition my affidavit filed in his earlier writ petition. Maybe the prayer in that writ petition may be something else, but the fact we have disclosed, that you see in respect of which you are seeking sanction, that falls within the acquired area, that is acquired land. So meanwhile, another fact has come into, my lord. This writ petitioner filed another writ petition, that is WP number 6035 of 2020. Ultimately, my lord, that was withdrawn with the liberty to file afresh. That is at page 127, the order they have annexed.
Yes.
I must, my lord, refer to the fact, my lord. This is the writ petition seeking the same prayer, but for the reasons known to them, that was withdrawn.
One Pradeep Chakraborty filed a writ
Yes,
petition.
I'm coming to that. My lord, this writ petition moved by Ganesh Adhikari, but withdrawn with the liberty to file afresh, and this writ petition was filed. This is one chapter. The Pradeep Adhikari, Pradeep Chakraborty, who is the son of Kanchanbala Chakraborty, filed a writ petition challenging the acquisition process.
Yes.
That writ petition was heard and ultimately dismissed.
Dismissed on merit.
Dismissed on merit.
Not on merit. Not on merit.
Yes, on
No,
that, on of course, so it is on.
But since
you have averted in your writ petition, in your pleadings, that regarding that writ petition.
yes, but not on merit, my lord. That is only on the.
You have submitted.
Yes.
The property was transferred.
And you have transferred it.
Yes.
So you have no right to ask.
Yes, division bench held.
Yes, I know that.
That touches the.
That is the merit.
Yes, of course. So, my lord, the fact emerges from this, my lord. The petitioner, though not specifically challenge the acquisition proceeding, and the prayer in a manner caused, my lord, it can't be molded in my respectful submission.
No, he has not mentioned the LA case number in the writ petition, but challenge a LA proceeding. But the document shows there is a existence of LA proceeding.
Existence of LA proceeding.
Whether that can be molded.
Yes, because that cannot be molded for the reasons, my lord, in my respectful submission to my understanding, my lord. My lord will see that by a notification, when an acquisition notification is issued, that comprises several plots and the quantum of huge quantum of land. If someone is aggrieved in respect of his property, in respect of 1 or 10 plots, as the case may be, he must specify his ownership and title to the property in order to ventilate his grievance, and to seek relief specifically, that because the acquisition proceeding as a whole cannot be challenged at the instance of anyone else, because all the plot owners, the plots comprises in that notification are not before the court, and notification was never challenged, never upset at the instance of anyone else. Here the petitioner in the prayer neither does specify the acquisition proceeding, nor the quantum of land, not even the plot number. So, And that too, when they are coming to, if assuming, my lord, this I'll be making alternative submission, that even assuming there has been a challenge, this challenge is belated. Acquisition proceeding was initiated in 1976-77.
Yes.
And this petition, my lord is considering, is of 2020. So there has been a delay of about 40 years, and that too unexplained delay. The acquisition proceeding, which has reached its logical conclusion, my lord, whether that can be reopened at the instance of an individual who comes at a belated stage when the proceeding has been completed and concluded and reached its finality. My lord has seen the wordings, the award, the award becomes final in between the collector and the person concerned.
Yes.
Whether that can be reopened. Whether, and it's a fact, my lord, there has been no explanation about. Then, my lord, I have taken the point, I have made submission that dismissal of his earlier writ petition, my lord, it is the basic principle of law, my lord. When someone comes to the court, he must come with clean hands. He must disclose all the facts he is aware of. But here, his earlier writ petition, not even when we have specifically pleaded in our opposition, taken that point, he has not disclosed that writ petition. That fact may not be material, but he ought to have disclosed that when we are questioning that. Their suppression lies on the part of the petitioner. And then, my lord, lastly, my lord, I will be taking that point, that principle of res judicata will also come into play. Though not, my lord, why are you laughing?
How principle of res judicata can apply?
My lord, principle of res judicata here, if I say in respect of this particular plot of land.
Is their issue decided?
Issue not that it is not a strong point, my lord, I must say.
Additional.
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 So, my lord, my first point would be the delay, which is apart from the maintainability of the writ petition on two counts, what I submit. The petition cannot be entertained. Even if entertained, then these points comes in, my lord. Here, lordship kindly takes the date, my lord. I will be referring to the pages, my lord, now.
Yes.
My lord, page 112, lordship kindly have a look. 112. তোমার পিটিশনই তো বলছি। Certain documents, my lord, the dates are necessary. This is, my lord, this acquisition was done under Act 2. The possession was taken, my lord, on 7 September 1979. My lord, this is what I am showing, my lord.
7 September 1979.
The left hand side at the bottom, lord, you will find that.
Possession of taken and delivered.
Collector takes possession and delivers it to the requiring authority. Then Lordship kindly come to page 116. From his writ petition, I am showing this. This is the notification which is referred to LA 2 of slash 105 of 1976-77. This involves the Lordship at 100 and type copy Lordship. If you take takes the type copy at 120. 120 right inside column, serial number third Lordship will find the particular plot number. My Lord has seen
2456.
2456. Lordship will
Area covered by structure.
excluding the area covered by structure. Initially, the structure
25 decimals.
Yes, 25 decimals. My Lord, I am coming on this notification once again. Then your Lordship kindly turns to 122. This is the award passed. And name of the Kanchanbala Chakraborty, Milord, much emphasis, Milord, was put by my learned friend on this, claiming apportionment and all this. But facts remain. The name of the erstwhile vendor figured in the award list at page 23, 123. At the bottom, Lordship will find the name of Kanchanbala Chakraborty, the erstwhile owner or vendor of the petition. Then, my Lord, I have already referred to 125 of the joint demarcation. So, my Lord, here Lordship will, my Lord knows even then, my Lord, once again, may I refer to one provision of section. My Lord has got Act 2. If you, for my satisfaction, if you Lordship takes up section 4 of the Act 2. The consequence of issuance of notification.
Land acquisition আছে এখানে সব।
It will not be. Only this publication once it was available, but later on it was not. And that act is available in West Bengal laws.
West Bengal. Yes. রাখুন।
না পাবেন না, এটা ওই ফর্মে নেই। If your Lordship takes up section 4, this is the notification issued under section 4(1)(a). Lordship, what is 4(1)(a) and what is the consequence of issuance of that notice? Lordship, kindly appreciate. This comes, my Lord, first requisition under Act 2, first requisition, and followed by acquisition. Acquisition is done with the issuance of section 4(1)(a) notice. My Lord, may I read section 4? Acquisition of land. Where any land has been requisitioned under section 3, the state government may use or deal with such land for any of the purposes referred to in subsection 1 of section 3 as may appear it to be expedient. So, the government can acquire, may use. Now 1(a), Lordship. The state government may acquire any land requisition under section 3 by publishing a notice in the official gazette that such land is required for a public purpose referred to in subsection 1 of section 3. So this is what Milord 116 is section 4.1a. Once this notice under section 4.1a is issued, what is the consequence? The next two, Lordship, kindly. I'm reading this. Where a notice as aforesaid is published in the official gazette, the requisition land shall, on and from the beginning of the day on which the notice is so published, vest absolutely in the state government, free from all encumbrances, and the period of requisition of such land shall end. So with the issuance of section 4.1a notice, the land gets vested absolutely free from all encumbrances, to the exclusion of all other. The government becomes the owner of the land. And from the facts, my lord has seen that the demarcation on, even on joint demarcation, he was found to be occupying the government land. My lord knows this practice, my lord, when a land is acquired for the requiring authority.
Yes.
The process under section, if it is acquired under Act 2, that upon requisition, the land possession is taken and the possession is given to the requiring authority,
Yes.
whoever may be. Here, my lord has seen that on 7 September 1979, the possession was taken over by the collector and given to the requiring authority. After the requisition, what is to be done, my lord? If the government so feels, my lord, to acquire that land for public purpose, section 4 is resorted. Here the section 4 was resorted to. Notice published. And in view of subsection 2 of section 4, land gets vested absolutely to the state. And there is no rebuttal. And my lord, that the award was also duly passed. After this notice was published, there the obligations of for the collector was to pass the award. Here it is no doubt, my lord, that award was not passed. Award was passed, and the erstwhile Bhendi, the Kanchanbala Chakraborty, her name was figured also in the. So regarding the acquisition, there can be no question. So now whether that acquisition can be challenged.
Okay, that's all.
No, not completed. Not completed, my lord. I will have to cite some judgments.
Okay, you want.
So next Thursday.
Today, shall you continue?
No, next Thursday another matter is faced before your lordship. That will take time.
Next,
Mr. Mukherjee is arguing.
Okay, next Thursday.
The Thursday next.
Friday.
Thursday next. Thursday next.
So, Mr. Mukherjee matter was fixed on when?
Next
Thursday at time?
10:30, but that will take time. That will take time.
10:30.
Next Thursday.
Second matter?
Second matter. If you I do not have.
I am ready.
I will have to
Whether
go
you are
before
ready
your
or not.
lordship for that matter.
Okay.
So I will be citing some judgments and conclude.
His judgments are most lethal. He has so many unreported judgments. He always, on the other side, is
No, here nothing is
Very good.
unreported.
All are okay.
Unreportedly.
Argument on behalf of the KMDA continues. Let the matter appear in the
Unreported ফাইল পার করে যখন তুমি
on
মাথা খারাপ হয়ে যায়
28th of August 2025 under the same heading.
As second matter. As
10:30 you want?
10:30 already one matter is fixed. That is Mr. Mukherjee's matter.
10:30 as second matter.
If it is-
Yes.
Route number 8 could just be matter will call public interest
Today,
It
28th. Next. Let it be in the list there.
Lordship, may I, Lordship, my,
Yes.
my junior mentioned in the morning this port. I'm for the port trust. For 13 years, we are suffering a status quo with regard to 18 bighas of property.
Yes, he
Lordship,
mentioned.
item 43 today will not be called on because Lordship's special. If it can be tomorrow, any time, Lordship, if it commence, I can try whenever if Lordship commence tomorrow, anytime.
দেখি ডায়েটে দিন এটা নিয়ে না number 43.
Yes, my lord. Shubhi Roy was a port trust.
Who is for the petitioner?
We have given them notice. We shall intimate them once more. If Lordship, we had emailed them.
Okay, please take down. On mentioning this matter, item number 43. We appear in the list on 29th of August 2020.
That's the only day I'm not there for personal reasons. If it can be 27th, 26th.
27th, I have fixed 28th is the day when I can take up this Mr. Mukherjee matter will be taken up
So
entire
second
day.
half, if it's possible.
Second half, I have the original side. Today also and
Then
Friday.
Lordship, kindly keep it the week after that kind.
Week after then. Then it is
11th, on the 4th of September, if it commences.
Let's see. তাড়াতাড়ি কি আছে সার্ভার একটা আছে নালে ছাত্রে ছেড়ে দিন তাহলে 11 তারিখে দেখুন 11 তারিখে 12:30 11th
11th, my lord.
let it be appear on 11th of September 2025 at 12:30.
I'm grateful.
The respondent is to serve notice upon the petitioner regarding the fixing of date.
I'm grateful.
Call the list.
But item number 1, I was appealing for the writ petition, my lord. I'm led by Mr. Somu Mujumdar.
Malati Saha and others versus Indian Corporation. I am reading only the operative portion.
My lord, kindly.
The duty of the distributor to provide LPG of correct weight cannot be denied. Manufacturer may supply underweight cylinders, but it is the duty under contract of the distributors to supply cylinders of actual weight. In this case, the petitioners, being the distributors, has failed to perform his duties and loaded underweight cylinders in delivery van. Thus, in this case, in my view, the impugned order imposing punishment and fine upon the petitioner is not unreasonable. Under the above observation, I find no justification to entertain the petitioner. According to writ petition, dismissed and disposed of.
My lord, only one indulgence I was seeking. Lordship kindly will consider my one prayer, my lord. My lord, there was an interim order staying the operation of the order under challenge. My lord, from time to time, that has been extended by your lordship, and that was till the disposal of the writ petition. Now, my lord, if my client intends to prefer an appeal, my lord, 30 days time is there. Now, my lord, if I will beseech your lordship, my lord, to my lord, let the stay there be granted for another 30 days, because if my clients can prefer an appeal and obtain a stay before the honorable division bench, then that is okay. Otherwise, if they do not prefer an appeal, then my law will take its own course. But the difficulty is that with the dismissal of the writ petition, not the amount that is to be paid by me as the penalty, that will be automatically credited to the account of the order as order under challenge. That is why I
Want
was
extension of interim order till the appeal period.
till 30 days, so that if my clients want to file an appeal, then my lord, within 30 days.
In view of the dismissal of the writ
Latter.
petition.
Yes, only 30 days, only 30 days.
Latter.
So that if my clients prefer an appeal, then my lord.
And after
Learned
It
dismissal,
is auto,
submits that
it will be auto debited. It will be auto debited.
interim order passed by this court till the disposal of the instant writ petition. As the writ petition is disposed of, automatically the interim order is vacated. He submits that the petitioner intends to prefer an appeal against the instant order. So the interim order may be extended further period of 30 days from date, so that the petitioner may approach the appellate court for have an interim order, which was existing till since the filing of the instant matter. Mr. Nag, Mr. Nag, learned counsel appearing on behalf of the in behalf of the Indian Oil Corporation Limited, raised strong objection. Having heard the learned counsel for the petitioner and considering the entire circumstances, the interim prayer for interim prayer for extension of interim order is hereby considered and rejected.
Grateful one.
Next, call the list.
So this is my application.
Lord, I am opposed to this.
Lord,
For different number 1.
Mr. Ray was making his submissions on it, my lord. My lord, he had placed some of the agreements. Lordship recalls this is, my lord, the probate proceedings pertaining to, my lord, the estate of
My lord, I have been, my lord.
Mr. Shurojit Mitra was there. Thereafter,
Sorry, my lord, yes.
Banerjee has taken
Okay.
over the reins, I guess.
Just
To oppose, my lord, Mr. Ghosh, my lord, is
okay.
to oppose him so that, my lord, no prayer, relief.
To oppose
no
to
prayers
ensure
are-
that the estate is preserved. Mr. Banerjee is here. He will.
First, my lord, he has to show what is the estate. Without showing what is the estate, my lord, he can't have any orders. My lord, this.
Yes, yes.
Mr. Basu has intervened.
Yes, Mr. Basu, what is
Only to know, my lord.
Only attach your estate.
How long they will continue so that I
Estate too much.
No, it will take time. It will take time.
Time lag.
আন্দাজ
ও কতক্ষণ বলবে জানি না আমরা।
1 ঘন্টা তুই
তুই 1 ঘন্টা বলবে?
18 minutes time.
সরি মালাট।
তুই 1 ঘন্টা
না আমি পরে দিন।
না, 1 ঘন্টা শেষ হবে।
শেষ হবে না।
At least for 1 hour we are really. Okay.
অনির্বাণ বললো বলতে চায় না।
Yes, proceed.
Yes, my lord. Lordship recalls, my lord, there was originally a settlement between the family members, my lord, the sons, the daughter, and my lord, the husband and the wife.
NL group, PK group, RK group.
Exactly, my lord. Now, in contravention of, my lord, the two original settlements, my lord, we come to learn of this alleged settlement of 2019, which saw the light of the day much after, my lord, the demise of, my lord, the said Nandlal Todi. Now, if your lordship sees this agreement, which is at page 68 of, my lord, the affidavit filed by Mr. Pawan Todi, being the defendant number 1. Now, affidavit in opposition.
Ma'am, Shanti Devi's signature. Thanks for himself and Shanti Devi is home authorized. Registered.
G3 opposition.
Malad, I don't want to, Malad, in that sense, interrupt Mr. Ghosh, Malad, he can make his submission. But one, Malad, I've looked at, Malad, the brief and, Malad, the affidavits. Malad, one thing, Malad, in a, if he wants, Malad, any appointment of an administrator and to preserve the estate, but I understand, Malad, the first thing he has to show is, Malad, what is the estate? Now, Malad, by relying on settlements, Malad, which are of 2009, it can't be, Malad, that he will say that now I'll make my submission detailed, but Malad, he should also address that point, Malad,
Yes,
when
yes,
he's making the
Malad,
submission, so that, Malad,
I-
issues are narrow before my lord. So
Yes.
that, Malad, we don't, Malad, go on, Malad.
But I believe, my lord, I think
I'm
this-
sure he'll do it, Malad.
Yes,
Knowing
yes.
Mr. Ghosh,
Not
Malad,
just that, it's already been done. Mr. Banerjee was not here, my lord. I think that's, I think, my lord, that's perhaps been done. Yes, yes, perhaps. my lord.
is comprising of shares, Malad,
Yes, my lord, I'll
and
show,
companies.
because I'll again show it.
Very.
I'll again show it once more. There's no difficulty. So this alleged settlement, which is at page 68, Lordship will kindly take note of it. My lord, Nandlal Todi, Shanti Devi Todi, my lord, they are arrayed as the first parties to the agreement. Now, my lord, the other son, which is the defendant number 1, is a party and is the party of the second part. They record, my lord, this agreement records, my lord, the settlement of 2009, 28th September 2009, 29th September 2009, and the 1st October 2019 agreement.
Yes.
Now, if your lordship turns over to page 71, kindly sees what they are attempting to have disclaimed based on this agreement. Now, this memorandum witnesses and it's agreed and declared by and between the parties hereto as follows. Disclaimer, the first party, that is Nandlal Todi and Shanti Devi Todi, allegedly is disclaiming their rights, title, interest claims regarding the following properties. A, 225B Agency Post Road, which the family held through another company, which again, my lord, is not in dispute. 12B Beleghata Road, which again was to be held through another company. Shodhpur land, a building which is at Todi Mansion, that building, and Maniktola Main Road. These are the rights which are being disclaimed by, Lordship will kindly see, Nandlal Todi and Shanti Devi Todi. The first parties thereby clarify and confirm that they have relinquished all their rights in the above properties arising from the family settlement agreements and thus not retaining any such rights and shall not claim any rights in the future. The first parties further confirmed that the joint compromise petition filed on 3rd December 2014 before the Civil Court, in which, my lord, the members of the first parties had transferred and disclaimed all their rights, holds true and valid even today. First parties further declare and confirm that the affidavit as filed by the first party number 1 on 18th August 2018 in the court of the learned second civil judge in title suit number 857 was done under immense pressure. This was, in fact, my lord, a affidavit which was filed by the deceased calling out the actions of my lord Pawan Todi, the defendant number 1. This is the suit 857 of 2018, the suit which was pending in Alipur, which has been filed by the defendant number 2, in which, my lord, the father took a stand supporting the defendant number 2. This document, why this is suspect, I'll just indicate. Firstly, this affidavit, completely contrary to what has been stated in court, they are trying to overcome that affidavit by way of this agreement between defendant number 1 and, my lord, the deceased. The first party, number 1, expressly withdraws and resigns all that is written in such affidavit. So, my lord, kindly considers this, that the father, by way of an affidavit, affirms it and places on record certain facts before court. Surprisingly, the defendant number 2 is kept in the dark. The defendant number 1 allegedly gets a settlement done between the father and the defendant number 1. The first party was forced to do under pressure from his younger son and his family, and places on record that the above mentioned affidavit should not be considered for any purpose whatsoever. Then, my lord, what is being transferred? Paragraph 2 at page 72. The first parties have already gifted their entire shareholding in the following companies to whom? No one, just Pawan Todi. And further confirms that such disclaimer of all and every nature and manner of right and title and interest in all these companies, including their assets, my lord, and list of companies are there. And, my lord, thereafter parties put their signature. Now, if your lordship sees at page 73, who has signed? My lord, Nandlal Todi is signing on behalf of himself and Shanti Devi Todi. Lordship will kindly, I'll trouble your lordship once more. Lordship will kindly take the application, GA3. Well, page 21, if your lordship sees, that is the first memorandum of settlement, 28th of September 2009. And this document, I'm sorry, my lord, yes, that is the first settlement. This document, lordship sees, Shanti Devi Todi is a party, and
Sushma Bajoria.
Lordship will kindly see, yes, my lord. At page 40, Nandlal Todi signs, Shanti Devi Todi signs, and Sushma Bajoria signs. So, my lord, the original settlement, not just, my lord, the testator, even his wife and the daughter signs, all the sons sign, and a settlement is arrived at. This settlement along read with the two subsequent supplemental agreements, delineate what is the estate of, my lord, the deceased. There's a schedule which indicates what is the estate, how much is to be held by whom, and, my lord, along with that, there's an issue with regards to affirmative rights. Certain acts, my lord, cannot be done without exercise of these affirmative rights. Controlling interest. Now, my lord, if your lordship sees page 73, in the affidavit in opposition,
yes,
no signature of Shanti Devi Todi, no signature of Shushma Bajoria, and no signature of R.K. Todi. I hear, my lord, Mr. Shorka's statement that there was a power of attorney. The power of attorneys can come and go like this. Mr. Shorka has it up his sleeve.
yes. Proceed.
This agreement challenge
Yeah.
that.
Now, my lord, kindly seize, my lord. Yeah. There is no assertion where the signature appears of Nandlal Todi in the document of 2019 that this document has been signed by Nandlal Todi on behalf of Shanti Devi Todi as her attorney. He's only signing for himself and Shanti Devi Todi. So this statement which has been tried to be conveyed across the bar that there was a power of attorney, this again is, my lord, so
you proceed.
Yes, my lord. Now, if your lordship sees this document, my lord, this agreement of 2019, this is under challenge in the suit which is pending adjudication. This document has been challenged not just, my lord, by the propounder, but also, my lord, the defendant number 2.
That is 4th day of June 2029.
Yes, my lord.
2019.
Both. No. No.
Yes.
My lord, that suit has been disclosed by way of a supplementary affidavit by, my lord, Pawan Todi, the defendant number 1. First, second, third, fourth. The suit is at page 12 of the supplementary affidavit. This is affirmed on, my lord, in July 2025. No. Application. If I could, and my lord, in the other application, which is GA4, Mr. Banerjee's clients have also disclosed the suit which has been filed by Rajkumar Todi, challenging the same document of 2019. My lord, the defendant number 1 has also disclosed another document which is at page 102. This also, my lord, purports to be a settlement, which is again also under challenge. This settlement, my lord, which is dated 28th March 2024, at page 102 of the affidavit in opposition, is not binding on the propounder.
One zero
102.
AO by defendant number 1. Supplementary.
Yes, my lord. Different AO, the affidavit in opposition. Well, where the 2019 agreement is settlement is disclosed, the same document, well, the same affidavit. This document, my lord, which is at page 102, Lordship will kindly see the averments in the affidavit, which is at page 9, paragraph Q. Kindly sees how this document has been introduced. Subsequently, after filing paragraph Q, my lord, at page 9.
Yes.
Paragraph 6Q.
Yes.
Subsequently, after filing of this present proceedings, probate proceedings, a memorandum recording settlement dated 28th March 2024 was entered into by and between Narendra Bajoria, Sushma Bajoria, and Neeraj Bajoria, hereinafter referred to as the Bajoria Group, and Pawan Kumar Todi and his sons. A copy of the memorandum recording settlement dated 28th March 24 is annexed here to marked with the letter F. Now, my lord, this paragraph, this is 6Q, but we'll kindly see how it has been verified. I'll indicate why this is relevant. This is at page 22, paragraph 22. It's stated, my lord, it's verified as true to knowledge, but it's based on knowledge derived from records and believed to be true.
Paragraph 6.
Yes, my lord. 6. That is how it is verified.
Yes.
Now, if your lordship turns to page 102, the alleged settlement names the propounder of the will along with his mother, along with his father and wife and mother. Kindly sees, my lord, the said document is nowhere signed by the propounder.
Who has signed?
Not signed by the said Neeraj Bajoria, who's the executor of the will of Nandlal Todi. So the averment, he's named as one of the parties, allegedly. At page 127, the signatures appear of the respective parties. So, my lord, at 127, the signature of Mr. Neeraj Bajoria and his wife are not there. And the witnesses I am, my lord, entering into a settlement of my own volition with my eyes open. And there is nobody to testify as to the circumstances under which it was executed on my behalf. Mr. Bajoria, Mr. Neeraj Bajoria, who's the executor, or his wife, neither of them have put their signatures to this document. But on affidavit, if I may take your lordship back to the paragraph 6Q, on affidavit, specifically, they take the name of the executor.
Paragraph 6Q.
6Q at page 9, turning over to page 10, my lord.
Yes.
Specifically take the name of Neeraj Bajoria. So the attempt is that the executor, post filing of the probate application, has acted in contravention of the probate proceedings and have entered into settlement with defendant number 1. Whereas in the document itself, there is nothing to show that. And what is surprising is this, my lord. Probate proceedings is effectively, my lord, it is to satisfy the conscience of the court whether the testator on the eve of signing the will had the capacity to execute, and whether, my lord, the persons who were present as the attesting witnesses had seen him sign the document. Testamentary capacity.
Yes.
So, my lord, even if I take it to be true that if it is for the sake of argument taken, no executor can overreach, my lord, once the probate proceedings have been started. It is in rem. Nothing. Proceedings are in rem.
Yes.
Now, my lord, this document again is the subject matter of a pending suit. Because, my lord, we were aware that this is what is going to come from them. So, you have given up your rights. You can't proceed with the probate. So, we challenged it. And that is also pending adjudication. So, this is where, my lord, we stand today. Now,
So these are the entire facts.
Yes, my lord. Now, in what the defendant number 1 effectively has done is this. They've gone behind the executor and dealt with the estate of, my lord, the deceased. Substantial depletion. But paragraph 15 of my application, my lord, if I may just place the same at page 6. Lordship has that, my lord. The memorandum recording oral family settlement dated 28th September 2009 contemplated joint ownership of a company, namely Akshay Vinimay Private Limited,
Yes.
in a proportion whereby Nandlal Todi Group would hold 25%, Raj Todi Group would hold 25%, and Pawan Todi Group would hold 50% of the shares in the company. None of the shareholders were authorized to independently, singularly operate, own, manage, and implement transactions on behalf of the said company. This is what, my lord, is the affirmative vote that I was talking about. It was further recorded in the memorandum recording oral family settlement dated 28th September 2009 that the property at 12B Beleghata Road, in which the said company had 50% joint development rights, would remain the joint property of Nandlal Todi Group, Raj Todi Group, and Pawan Todi Group. The property at Beleghata Road has been developed jointly by the said company and Transways Enclave LLP into a project by the name of the Crown. The said company has subsequently been converted into a limited liability partnership by the name of Akshay Vinimay LLP, having its registered office at 12B Beleghata Road. Again, contrary to, my lord, the family settlement, and, my lord, in contravention of, my lord, the affirmative rights. The flats comprised in the projects are currently being sold by the developer and Akshay Vinimay. Akshay Vinimay was a joint ownership of NL Group, PK Group, and RK Group. Monetary benefits, flats to the extent of 12.5% would be the share of the testator and would form part of the estate of the deceased. It is apprehended that the proceeds received from the sale of flats in the project, the Crown, are being appropriated, used, or removed in a manner which is prejudicial to the interests of the estate of the deceased. The aforesaid removal and dilution of the estate of the deceased would cause irreparable loss and injury. Well, there are documents which I can show that 12B Beleghata Road is being developed. They've already done with regards to the Baliganj property, which is AJC Bose Road. Lordship will, right at the crossing of Baliganj Circular Road, which is below the reserve building, there was a substantial right there, which has been alienated. देखिए ना वो কি আছে Lord, if your lord, I can hand it over, my lord. I was hearing murmurs that it's not part of the record. Crown. So this is the development which is taking place at 12B.
But you should put it, my lord, in affidavit.
Yes, I'll put it on affidavit. There's no difficulty. I'll put it on an affidavit. I'm just showing it.
Documents by without.
I'm sure it is developed. 12B Beleghata.
Put it on affidavit.
I'll put it on affidavit.
They have to.
No problem.
A lot of interesting development. I'm sure, my lord, properties around in Kolkata. So that doesn't mean, my lord, my learned friend's client will have any right over it.
So that court will adjudicate.
Correct.
Yes.
Well, may I come back with the judgments, my lord, on the next?
No, let him come back. He's not finished yet.
So that's the reason why, my lord, since if he wants to come back on the next day and then argue, and if my lord is posting it for another day, my lord, we and the defendant number 2, we had taken out an application GA2 of 2024, in which, my lord, an interim order was passed on the 15th of July 24, last extended by my lord on 25th of July 2025. Well, I was only seeking, my lord, extension of this.
I'm of course opposing it, but whenever, my lord, their application also comes up, my lord.
Yes, my lord. This is
finishes.
listed today because my lord had directed that this is to be listed today. It's listed today. So my lord will kindly extend this interim order.
So we have concluded the facts.
Yes, my lord. Factual portion we have concluded.
You serve the affidavits like that?
Yes, I'll put it on an affidavit, my lord.
I've also, my lord, told my learned friends only because I've come in, my lord, new. So I asked them to, my lord, prepare, my lord, a compilation of documents which will be very useful to, my lord, just to, my lord, look at the documents one by one after the other.
We'll do that.
When the matter can be concluded.
My lord, next Thursday we'll do it. Lordship takes this up on Thursdays, my lord.
Yeah. অর্ডার বুকটা কোথায় গেল?
কবে করব? নেক্সট থার্সডে
27 তারিখ তো থার্সডে 27 না 28 হবে
27
বুঝে
না থার্সডে আর ফ্রাইডে না
হ্যাঁ
থার্সডে আছে দুদিনই লিখে দেবো। আরে এটা আসবে ফোর্থে
ফ্রাইডে 28 তারিখ ফ্রাইডে আমি
4th September.
4th September.
not 4th well I have personal difficulty but I'm not there.
Then it would be 11th.
11?
What?
11?
I guess it's
11 or 12?
So can be before any day if your lordship can accommodate us.
No, issue is that only 28 and 29 have fixed some matters.
Yes, my lord.
28
Long matters are there.
28 it's not possible.
28 not possible.
হবে না
Already I have fixed the
28,
matters.
My lord has fixed
In the second
matters.
half, already I have fixed other matters. Mr. Mukherjee is arguing this.
Oh, I see. Very well.
So,
Then not fourth,
either 4 or 11.
not 12th, is it possible?
Yes, 11, 12.
12.
No issue.
11, 12?
Please take down argument on behalf of the petitioner. Plaintiff continues. Let the matter appear in the list on 12th of September 2025 at 2 p.m. as a specially fixed matter for further argument. Full stop. Next para. Interim order in connection with GA 2 of 2025. Which was extended time to time, is further extended till 19th of September 2025 or until further, whichever is earlier.
Great. Well, I'm opposing, but well, I'll make my submission
Yes.
on the next.
Other applications being GA 2 of 2025 and GA 4 of 2025 shall appear on the same day, that is on 12th of September 2025 at 2 p.m.
Great.
To Joseph only 12th.
Great. Plaintiff petitioner shall file affidavit coupled with some documents they intends to rely.
And my lord, if my lord also give us leave, my lord, to file my lord any affidavit, my lord, to their affidavit.
The defendants are also at leave to file counter affidavit.
Grateful.
Great. Grateful, man. You know, it is GS3.
Item number 3.
Item number 3, can you make it for possible? Mr. Lassi is coming.
Item number 4. Item number 4, I'll come for the petition. Item number 4.
This matter with regard to appointment of MR dealership, can you come to the page 90, vacancy has been declared. Page 19. Page 19, my lord.
Yes.
As an declare, I applied for vacancy, page 23.
Yes.
Page 23. Page 25, inquiry has been conducted. Page 25.
Yes.
Now, Salin, I come to from the portal. চার তিনটা পাসওয়ার্ড on the portal on 23rd 6 2025 then my application will be rejected by the director without any reason.
You made representation.
I made a representation page 27.
Yes.
I just want to consider this reputation by DDP. But what is the ground for rejection
By director DDPS? Have you served?
Yes, madam.
Affidavit of service is there?
In the original set, I first put the affidavit service, then matter
Okay.
come in the list.
Please take down. Affidavit of service filed on behalf of the petitioner put on record. Inspired service none appears on behalf of the respondent authorities. Full stop. Petitioner applied for license of MR dealership in pursuance to a vacancy notification dated 1st March 2024 issued by Subdivisional Controller Food and Supply Gangarampur. Application of petitioner was accepted online by giving him application ID on 25th of April 2024. Full stop. Proposed shop cum godown of the petitioner was inspected. Proposed shop cum godown, proposed shop cum godown of the petitioner was inspected by the concerned inspector of SCFS on 29th of May 2024. Whether you call for an interview?
Yes. That now days, my lord, sometime notice has been given and sometime over telephone is called.
No, whether you have appeared in the interview?
Yes.
The petitioner was called on for an interview by the district level fair price shop selection committee where he appeared.
Interview take place, file cannot be sent to the director.
Okay. Fair price shop selection committee where he appeared. Full stop. Thereafter, suddenly the petitioner came to know from the relevant portal of the department that the candidature of the
he is not.
That the candidature of the petitioner was rejected without assigning any reason. Full stop. Petitioner promptly approached to the principal secretary as well as the director DDPS Food and Supply concerned through a representation dated 25th of June 2025 within bracket annexure P6 of the writ petition. Bracket close. In spite of receiving such representation, the authority concerned has not responded to the petitioner. Hence this writ. Having heard the learned counsel for the parties, also considering the approach of the petitioner that he is one of the applicant whose grievances was not ventilated properly. Accordingly, I am of view that the concerned respondent authority being Director DDPS Food and Supply Department Government of West Bengal must answer the must respondent to the representation of the petitioner being annexure P6 of the writ petition. Under the above observation, the incident writ petition is disposed of with a direction to the director, comma, district distribution, procurement and supply, comma, food and supply department, Government of West Bengal, being respondent number 3 of the writ petition to dispose of the representation of the petitioner dated 25/6/2024 within 6 weeks from the date of passing of this order, from the date of communication of this order, after giving a reasonable opportunity of being heard to the petitioner. Full stop. The decision of the authorities shall be communicated to the petitioner. Whether it is possible within 2 weeks. If it is 6 weeks.
4 weeks, 2 weeks.
Then it also within the vacation.
What happened, my lord? I was
4 weeks, I can understand 4 weeks, but if 2 weeks, it would be within vacation. Then within 4 weeks, let that. কি বললাম বলো? না প্রথমে 6 weeks করেছি না, ওটা 4 weeks করো। 4 weeks। তাহলে কি বললাম? After giving a reasonable opportunity of being heard to the petitioner. Full stop দাও। বলো decision of the authority shall be communicated to the petitioner within 4 weeks thereafter. Within 4 weeks thereafter. Full stop. Under the above observation, writ petition is disposed of. I make it clear that this court has not entered into the merit of this matter. Respondent number 3 shall independently dispose of the representation according to law without being influenced by any observation of this court. Since no affidavit has been exchanged between the parties, the allegation made in the writ petition shall be deemed to have been not admitted. The allegation may, since no affidavit have been exchanged between the parties, the allegation made in the writ petition shall be deemed to have been not admitted.
আগে হোল অফ করে দিই তারপর তো যা পরিষ্কার
Disposed.
But Mr. Bandyopadhyay, my lord, is on his legs before courtroom number 10, my lord. An appeal is
Which matter?
this matter.
For item number 3, my lord, he is appearing. But kindly, my lord, takes it up next week, my lord.
I have heard this matter, I think.
My lord, it was heard in our absence. Direction was passed. We have filed a report.
Have you filed the report?
My lord.
An exception also.
Exception filed. এসো
যে অর্ডারটা পড়ে নিতে
কালকে কি রাখা আছে?
কালকে লর্ডশিপস অর্ডার
কালকে যদি সময়
tomorrow first matter.
Oh, tomorrow Ponji matters, my lord, at 2. Only once in a week that base sits.
Tomorrow I have free. I am free in the second half.
My lord is free.
Yes.
I'm taking steps that my lord should not be free.
No, if I free in the second half, that is the less matter in original side. I will take up the again appellate side matters.
Can I take up, my lord? I will not be able
Okay. Okay. Then next
my lord.
Next Thursday.
I have no problem. Can I see your lordship? Consult your lordship.
Next Thursday, Mr. Mukherjee is supposed to argue on the matter, a long matter. I can fix the matter.
Mr. Mukherjee maybe
fourth.
Sir.
4th of September. 4th of September.
Yes.
4th of September. As pleadings are complete, I can conclude the matter on that day.
My lord, we have a point of maintainability in this matter.
Maintainability? Yes, you can raise it, no issue.
We have already raised.
Pleadings have completed so that I can dispose of the matter.
Enter it. With a one go.
Enter one go.
Next Thursday কি আছে? Next Thursday স্যার তো সকালে বলবে।
An accommodation is sought for on behalf of the state respondent. Let the matter be
in the morning.
2.
Oh, for 2.
Thursday.
Oh, sorry, I cannot express well that contempt matter of SSC.
That is Thursday, 4th.
Thursday, that is on Thursday.
I am taking up only the original side matters at 2. That is the difficulty.
Can I keep it for the time being at 4th? But you can
Okay. 4th. কি বললাম বলো?
And my lord accommodates everybody, so I will not be discriminated.
No, I am always there to accommodate you.
So no,
If you want tomorrow, any particular time at 3 or like that, I can also fix it.
But tomorrow or Friday there will be 3 times. It is in my head.
Maybe half an hour
We'll
is
argue the maintainability for half
is
an hour.
sufficient.
We'll argue the maintainability for half an hour.
That bench will, in all matters I am appearing. This
Okay,
won't
okay, okay, forget it. Then it is not possible. Counter affidavit. Who filed this?
They have filed me exception, my lord.
Okay.
Exception to our report.
তাহলে এটা প্রথমে লিখে দাও, counter affidavit on behalf of the petitioner to the report filed by the state respondent be taken on record. এটা প্রথমে হবে। তারপর কি লিখেছি? The anachrony short for on behalf of the state respondent. Let the matter be urgent today. List the matter on 4th of September 2025 at 2 p.m.
exception তো
কি করেছি দেখো না? এখন হয়নি দিয়ে দিয়েছেন। হ্যাঁ?
Lordship, you have not been served with the copy of the exception, my lord. I appeal for the private respondent.
You serve a copy.
No, my lord, what happened? He is appearing for the private respondent. He did not file any opposition. He is seeking for exception.
Exception to the state.
Yes.
The state is required to serve.
As the state already served.
You are not required to serve. Your report is not challenged. Their report was challenged with the exception.
Grateful, my lord.
কি হলো? এই তো দিলাম তো নাম।
Call the list.
আমি চলে গেছি। কোন দিকে? ও আচ্ছা আচ্ছা।
I think your lordship can recollect.
Yes.
Your lordship can recollect. On the last occasion I have submitted on behalf of the state under this Section 3A1 notice was issued under Act of 1941 on 24th November 1971. And the possession was taken on
16th of December 1971.
Yes.
Notification issued under Section 4(1)A,
Yes.
October 3, 1980. 27th October 1995, award passed. Reference code decree passed on 28th of June 2001. So your submission was that there are unexplained delay of 16 years in preparing this writ code. And you have also submitted that this court cannot set aside the decree passed by a competent civil court. That is the reference code.
Yes.
This is your ground.
Yes, my lord. But I am grateful to your lordship.
I have taken note of your all submissions.
But I have prepared a note, typed out the notes.
You can hand it over if you want.
Only for your lordships to
আমাদেরও কপি দাও, একটা কপি দাও।
now, my lord, your lordship will kindly see.
আমরা একটা কপি করিয়ে নেব।
But kindly see, the first point has to be decided by your lordship whether this writ petition filed in 2017 can be entertained by your lordships, challenging the acquisition proceedings, first requisition proceedings, culminated in acquisition, and passing an award by the collector, exercising the power under the Act of 1948, which has been amended in 1997. Then the reference was made. Reference court passed an award. Degree of the civil court. That's an appellable order before the civil court, before the division bench.
Yes.
Now, my lord, in that position, but whether lordships will entertain the writ petition to quash the entire thing the power exercised by the collector.
Yes.
Now, what kindly see the another judgment. So, what limitation is concerned. Huh? No, also disturb.
You have placed State of Madhya Pradesh versus Bhalla Bhai.
Yes.
1964 SCC online.
Yes.
And you have also placed 2014-11 SCC 744. Shiv Chandra More.
Shiv Chandra More, because of the res judicata.
Yes.
Because he
Principle of res judicata.
petition. Another point of limitation considered by the Supreme Court, 2009 1 SCC page 168. 2009 1 SCC page 168, paragraph 29 to 31. Here is this case also land acquisition proceedings.
On this point of delay.
On the point of delay.
Paragraph
29 to 31. And paragraph 16. Can you allow me to paragraph 16 first?
Paragraph 16.
Can you see? I do not. The paragraph 29 first. You also got here at page 175.
21.
Paragraph 29.
Paragraph 29.
Yes. In our opinion, the High Court, while exercising the extraordinary jurisdiction under Article 226 of the Constitution, is duty one to take all the relevant facts and circumstances into consideration to decide itself, even in the absence of proper affidavits from the state, instituted as to whether any case at all made out requiring its interference on the basis of the material available on record. There is nothing like issuing an ex parte writ of mandamus or direction in the public remedy. Further, while considering the validity of the impugn action, the inaction of would be free to satisfy the whether the case has been made out by a person invoking extraordinary jurisdiction under 226. The court, while exercising the jurisdiction under Article 226, is duty one to consider whether adjudication of the writ petition involves any complex and disputed question of facts and whether that can be satisfactorily resolved. But the question of fact is title deed has to be satisfied by your lordships. The writ petition reveals all material facts. The writ petitioner has an alternative or efficacious remedy for the resolution of the dispute. Person invoking the jurisdiction guilty of unexplained delay and laches, small d, expressly barred by any law of limitation. I'll press before our 66 Supreme Court because there is no limitation under Article 227.
Yes.
But Supreme Court says the civil suit filed has to be taken into consideration. Under Article 58 of the Limitation Act, maximum 3 years.
Yes.
Then in 2017, writ petition was filed. Entire proceedings initiated in 1971, culminated in 95-96. Even assuming for a moment, passing award by the learned LA judge. Then 2001, even that 17 years delay. I'll press before article. The court in appropriate case in the direction may direct the state or instrument the case may be to proper affidavits placing all the documents due to equity consideration of the court, particularly where the public revenue and public interests are involved. Such directions are always required to be complied by the state. No relief could be granted in the public remedy as a matter of policy only on the ground that the state did not file its counter affidavit opposing the writ petition. But the empty and self-defeating affidavits on statement of government spokesperson by themselves or they do not form the basis of grant of relief herself. No, none of these parameters have been kept in view of the High Court while disposing the writ petition and review petition. Then your lordship can see paragraph 31. Paragraph 34. 34. It will not be appropriate to dispose of the matter without one word about the conduct of the government reflecting the highly unsatisfactory survivors. We express our gross concern with the matter on which the state has conducted its case in the constitutional obligation duty of the state to place and true relevant facts by proper affidavits proving. The state and other authorities are bound to produce the complete records in order to ensure the government that they do not enjoy the same amount of direction as a private party in the government do enjoy the unlimited discretion in this regard. No one needs divine the state that represent. So in present case, and you see that is very vitally important is paragraph 30 and 31. Question of limitations.
Yes.
Now, another point they have taken that on the date of the award passed by the learned LA judge, he has no jurisdiction to pass the award because of the.
We have not taken that point. We have
No, on the entire land proceeding has been wanted to be set aside because learned collector has no such power to pass an award, and because of the judgment of our High Court Division Bench judgment, larger bench judgment, Justice Judge Bhaskar Bhattacharya, 2011, I placed before the Lordship. Now, the question is whether the collector exercising the power on the basis of act or on the basis of personal capacity. Now, that point has super as here. Where is the de facto doctrine would be applicable or not? 1981.
No, you are contradicting the argument of the petitioner. Which point you are raising?
So far as, but that collector, they want challenge the entire proceedings to be set aside.
Yes.
Land acquisition proceeding initiated, culminating in the award, after making reference before the learned LA judge, whether this could be set aside, and also the transfer took place after the award position taken over by the corporation to another third party. Public purpose is not there. That is their submissions. If
Two submissions mainly there. One is the lapse provision.
Yes.
The operation, it was award is lapsed.
Lapsed.
Entire proceeding is lapsed due to the operation of law. Second is that the purpose for acquisition.
Public purpose
Public
that
purpose is not utilized.
Utilized.
Utilized. Yes, that is two main grounds.
Two main
There
grounds.
are some allied grounds. Two main grounds.
Two main grounds.
main ground.
Yes.
We have not challenged the
When the-
acquisition, we have challenged the award.
Award.
Passed beyond the statutory period. This is number one.
You are saying
Second-
that by the operation of law, it has lapsed.
It has left. But award become invalid.
Award become invalid.
We are not saying for declaration that acquisition
Yes, yes,
proceeding
yes.
law lapse. We are
These are
saying
the two grounds.
yes,
they have argued.
award became invalid because it was passed beyond the statutory
Yes.
period.
And
And
this is the
second
two
aspect-
grounds. This is their submission. Now, what are you saying regarding the power of LA collector like that?
Yes, collector.
Okay.
So
So what is your submission?
1981, volume 3, SSC, page 132.
132.
1981, 3 SSC, page 132.
There are. In 81.
1981, volume 3, SSC, page 132. The kindly see paragraph 17. Under Supreme Court file pronouncing this.
17.
Yes. But the Supreme Court file pronouncing the judgment of Justice Ashutosh Mukherjee, 1912, 15 Calcutta Law Journal has been approved, and the Calcutta High Court judgment was correct. That favor. But now, if such, but kindly see paragraph 17. Paragraph 4.
Paragraph 4 first. Very good.
We are unable to agree with the submission of the learned counsel for the appellant. The doctrine is now well settled that their acts of the office de facto performed by them within the scope of their assumed official authority in the interest of public or third persons and not for their own benefit are generally as valid and binding as their acts of officers de jure. In a Pulin Bihari versus King Emperor, that is 2000 to 1912, 15 Calcutta Law Journal 517. As one of us has occasion to point out earlier that the doctrine of is founded on the good sense, sound policy and practical experience. Is aimed at the prevention of the public and private mischief and the protection of the public and private interest. It avoids all endless confusion and needless chaos. An illegal appointment may be set aside and proper appointment may be made, but acts of those who had hold office de facto are so easily undone and may have lasting repercussions and confusing sequels in attempted to undone. Hence the de facto doctrine. Then Malap paragraph 5. Pulling Bihari versus King and Sir Asutosh Mukherjee noticed that England the de facto doctrine was recognized from the earliest time. The first of the reported cases where the doctrine received judicial recognition was in the case of Abu Harsis decided in 1431. Sir Asutosh Mukherjee noticed that in 1431 the de facto doctrine appeared to be quite well known, and after 1431 the doctrine was again reiterated by English judges. Now paragraph 6. The question whether the judges who below properly judges or not can be determined. It is significant to be judges de facto. Suppose a person have been criminally convicted in a court and a record of such court was not duly recorded. The conviction would still to have a good in law, and he being the judge de facto. Then other judgments have been considered, and all the judgments. Then paragraph 9, Justice Lord Denning's judgment has been considered. Paragraph 10. The de facto doctrine has received judicial recognition in the United States of America. In the state of Garanda versus the question arose whether the office of bribe to bribe of the city commissioner whose appointment was unconstitutional was an offense. Said, we think that the principles of public policy declared by the English courts 3 centuries ago, which gave validity of official acts of persons who have introduced themselves as to the office which they had not been legally appointed, is applicable to the conditions now presented as they are to conditions that conferred to the English judiciary. We are not required to find out by name which officer to be unknown. We have acted under statute that is subsequently been declared unconstitutional, though we think that such officers might aptly be called de facto officers. Then kindly see paragraph 17. Now all the judgments have been considered. Then a judge who de facto therefore is one who is not a mere intruder or usurper, but one who holds office under the color of lawful authority. Though his appointment is defective and may later be found defective, whatever be the defect of his title to the office, judgments pronounced by him and acts done by him when he was clothed with such powers and functions of the office, elevate unlawfully have the same efficiency as judgments pronounced and acts done by the de jure. Such is the de facto doctrine, born of necessity and public policy. Can you see? Public policy. He is discharging the the duties under the Act of 1948, and his personal gain was not there. To prevent needless confusion and endless mischief, there is yet another side, the base of the public policy. The defective appointment of de facto judge may be questioned directly in a proceeding which he has be a party, but it cannot be permitted to question litigation between the two private litigation which is no concern or consequence to be the judge except as a judge. Two litigants litigating their private titles cannot be permitted to bring an issue litigating upon the title of a judge to hold to his office. Otherwise, as soon as a judge pronounces a judgment, a litigation may be commenced for a declaration that the judgment is void because the judge is no judge. A judge's title to his office cannot be brought into jeopardy with the fashion. Hence, the rule against collateral attack on the validity of the judicial appointment. To question to the judge's appointment in an appeal against judgment is therefore of course collateral attack. Who do not agree with the submission of the learned counsel that the de facto doctrine is subject to the limitation that a defect in the title of the judge to office should not be traceable to the violation of the constitutional provision. The contraventions of the constitutional provisions may be invalidate an appointment, but we are not concerned with that. We are concerned with the effect of invalidation of the acts done by a judge whose appointment has been invalidated. The de facto doctrine says such acts. The de facto doctrine is not a stranger to the constitution or to the parliament and the legislature of the state. But can you see the particular word? Article 17(1)(2) of the Constitution provides that acts done by President or Vice President in India in exercise of the performance of the powers and duties of his office shall not be invalidated by reason of the election of the person as a President or Vice President being declared void. So the section 107(2) of the Representation of People Act 1951 provides that acts and proceedings in which person has been participated in a member of parliament or a member of legislature of a state shall not be invalidated by reason of the election of the such persons being declared to be void. There are innumerable other parliamentary and state legislative enactments which had split such provision. The 20th Amendment of the Constitution, the instance where the de facto doctrine was applied by the constituent body to remove any suspicion or taint of the illegality or invalidity that may be argued to have been attached itself to the judgment. Degrees, sentence, orders passed or made by district judges appointed before 1966, otherwise than in accordance with the provisions of Article 233 and 235 of the Constitution. The 20th Amendment was consequence of the decision of the Supreme Court versus Chandramohan versus State of PB, that appointment of the district judge made otherwise than in accordance with the provisions of Article 233 and 235 were invalid, and such appointments had been made in any state in order to preempt mushroom litigations springing up all over the country. It was apparently so desirable that the precise position should be stated by the constituent body by amending the Constitution. See, Badke, learned counsel for the appellants argued that the constitutional body could not be imputed with the intention of making superfluous amendments to the Constitution. So Badke invited us to show that it was necessary to interference from the 20th Amendment of the Constitution that but for amendment of judges, degrees, etc., these judges appointed otherwise than in accordance with the provisions of Article 233 would be fired. Who do not think that inference suggested by Badke is a necessary interference. It's true that as a general rule that Parliament may be presumed do not make superfluous legislation. Presumption is not against strong presumption. Statutes are all provisions of introduced because of there is no harm in bringing the causes. When the judicial pronouncement have already been declared law on the subject, the statutory reiteration of law with reference to the particular case does not lead to the necessary interference that the law declared by the judicial pronouncement was not to apply the particular case, but may also lead to the inference of the statute-making body was mindful to the real state of the law, but acting under the influence of excessive cautions, and so the silence to the vices of doubting. The Thomas, by declaring the law declared by judicial pronouncement to be applicable to the particular cases. In Chandramohan's case, this court had appointed as district judge made otherwise in accordance with Article 233 of the Constitution were invalid. Such appointment has been made in Uttar Pradesh and in few other states. Doubts have been cast upon the validity of the judgment. Degrees, etc., pronounced by the district judges. A large litigations has been cropped up. It was to clear doubts that not to earlier law that such 20th Amendment of the Constitution made. This is clear from the statement and objects of the disease amended in Bill 2, which was passed with the 20th Amendment 1966 Act. Appointment of the district judges in Uttar Pradesh and few other states have been rendered invalid and illegal by recent judgment of the Supreme Court on the ground that such appointments were not made in accordance with the provisions of Article 233 of the Constitution. As a result of this judgment, a serious situation has arisen because of doubt has been thrown out of the validity of the judgment. Degrees, orders, and sentences passed by the district judges and a number of writ petitions and other cases have already been filed challenging their validity. The functioning of the district judge in the Uttar Pradesh has practically come to a standstill. It is therefore urgently necessary to validate the judgments, degrees, orders, and sentence passed or made thereafter by all such decisions in the state. In our view, the de facto doctrine furnishes an answer to the submission of Badke that Section 9 of the Criminal Procedure Code and Article 21 of the Constitution. The judges who rejected the appeal in one case and convicted the accused in another case was not mere usurpers or intruders, but such a persons who discharge their functions and duties of judges under the color of lawful authority. Remember the color of lawful authority, very important word. We are concerned with the office that the judges purported to hold. We are not concerned with the particular incumbent of the office. So long as the office was duly created, it matters not in the incumbent was not validly appointed. A person appointed as a session judge, additional session judge, or assistant session judge would be exercising jurisdiction in a court of sessions, and his judgments and orders would be those of court of session. They would continue to valid as the judgments and orders of the court of session. Notwithstanding that his appointment of such court might not be declared invalid. On that account alone, it can never be said that the procedure prescribed by law has not been followed. It would be different matter if the constitution of the court itself is under challenge. We are not concerned with such a situation in the instant case. Therefore, there is no space for submission of the counsel. Then,
no, which doctrine? This is the default doctrine, de facto doctrine.
De facto doctrine.
So,
but
what you want to prove by this judgment? What is your
collector,
point?
collector, while exercising the power, official power, not personal gain, or any other power.
No, they have not challenged the collector's power like that.
No, collector award has passed by whom? By the
Yes,
collector.
by the collector.
That on that collector has passed the award, that collector has no authority, or because the act validity of the act has been expired in 31st March.
So you are arguing that even if the argument is considered to be true, then also the collector's power to pass the award would be a de facto power.
De facto power. I'm grateful to Lordship.
This is your point.
Yes.
Okay. Okay.
And Mana, kindly see for a moment. Section 3(1). Your Lordship has seen Requisition Acquisition Act 1940 Act of 1948.
Hey, what is that? Land Acquisition and Acquisition Act.
When a possession was taken on 6th of December 1971, and when the writ petition was filed, that was filed on eighteenth of August 2017.
2017.
But there is no explanation for such an indefinite delay. Now, if the court has no jurisdiction, and what is the period of limitation? Kindly see the Limitation Act. Article 58 of the Limitation Act.
Yes, 3 years.
To obtain any other reliefs, declaration 3 years. But according to the Supreme Court, what would be the time period of limitation in a civil suit? That should be there.
Highest limit would be 3 years.
Oh, yes. And again, there is a question, is Section 22 of the Limitation Act. Continuing cause of action. But Section 22 continuing cause of action does not arise. Continuing cause of action arises only in a service jurisprudence.
Yes.
But that question came up for consideration before the Honorable Supreme Court. I'm sorry, my lord, I've got only one copy. Sorry, I have an unusual copy. Judgment of 18th of May 2022. Civil Appeal Number 4134 of 2022, paragraph 14. Civil Appeal Number 4134 of 2022. Reported judgment.
Judgment report
Reportable.
Reportable is not reported. Reportable means some important questions of law there. It is required to be reported. Some principles of law have been decided, but it has not yet been reported. That date of judgment কথা বললে? কেসের নামটা বলুন না। Date of judgment?
Date of judgment is 18 May 2022.
Party নামটা বলো তো?
Rasubhai Jagadish Pathak. Rasubhai Jagadish Pathak versus Bhavnagar Municipal Corporation.
Rasubhai Jagadish
Pathak.
Rasu.
Paragraph 14, last sentence. Tarsem Singh has a Tarsem Singh service jurisprudence. That apart, last sentence. Paragraph
Yes.
14, last sentence. From bottom third line.
Yes.
That apart, the date of decision of the single judge is the 50th October. Only the date of filing the writ petition is relevant while examining the question of delay and laches or limitation. Why I have pressed before Lordship the date of filing of the writ petition? 2017, 18th August 2017.
Yes.
Only the date of filing of the writ petition is relevant for examining the question of delay and laches or limitation. Have Lordship got it?
Yes.
If that be so,
স্যার এটা একটু জাজমেন্টটা দেন আমি ফটোটা করে দিচ্ছি
if that be so, then this court cannot question, cannot go into the other aspect of the matter, whether the collector has got any power or the acquisition proceeding is valid or not, or a public purpose is not that. if the writ petition is, if I file a suit for a money degree or for any other claim, there is a limitation. But if the court satisfied that no, the suit is not within the period of limitation, court cannot go into the other material contentions in the suit. And similarly, the writ petition, if it is not maintainable on the ground of delay and laches, because
in this matter, in a service jurisprudence, the question is the pay scale. The
Yes.
honorable division bench, honorable single bench has passed an order. Thereafter, it approached to the honorable division bench. Honorable division bench directed the pay scale should be from the date of order passed by the learned
yes,
single
it is
judge.
service jurisprudence. In a service
It is service jurisprudence. It is
But-
approached to the Supreme Court. Honorable Supreme Court says no.
No.
It would be from the date of filing of the writ petition.
Filing that limitation.
Yes.
Paragraph 14, last sentence.
Only the date of filing of the writ petition is relevant while examining the question of delay and laches.
Yes, yes. Only that sentence.
Yes,
Madam,
I understand.
am I clear to your lordship?
Yes.
Now, my lord, your lordship find whether if today the acquisition proceeding is completed, award passed, everything is over.
Yes.
If today my lord set aside that the entire proceedings accepted my lord friend's contention, no, there is no delay or etc. Then my lord transfer, question of fact, question of setting aside the transfer deed, question of fact. Then my lord public purpose, my lord science city, construction. My lord, this was initially for dumping ground of the waste materials.
Yes.
Inside the Calcutta city, near Port Circus connector. But in the meantime, you also were saying from 1971, more than 50 years, Calcutta has developed. Then, what purpose? But now the dumping ground has been shifted somewhere else because of the Pollution Control Board orders. We have shifted according to the order of the Supreme Court. But that is rather that there is there. But the fact is, today this place cannot be used as a dumping ground of the waste material because according to the order of the Supreme Court, we have shifted somewhere else, and there is a mechanism provided there, machinery is there.
Yes.
Now this practically we have not constructed anything. Still is a from 1971 to 1995. Initially, it was a dumping ground of waste materials of Calcutta. Then became a hilly, practically hilly area. Then somebody is there. That cannot be used by the corporations, only for the purpose of public. And the science city is for development of the knowledge and experience of the students and other public. And if it is not a public purpose, it's very difficult to say what is a public purpose. Because can you see the when the reference was made by whom? At the instance of the claimant.
Yes.
He could not have made the reference. No, you do not proceed with the reference. The acquisition proceedings is bad. Please stop here. In spite of that, he has got the knowledge that this acquisition proceeding is not valid, but he applied for deference. After making application for deference, can he say that no, this award passed by the collector or Lord Delay judge is admitted because this act lapsed on 31st March 1997?
Yes.
And Mother Kanishi, section 4. F2. F2. May I hand over, permit to hand over copy of the act?
আমার কাছে নেই, আমি একটা আমার দরকার, জজ সাহেবকে তো দেওয়া আছে আমাদের কপি।
Act of what? Act of 2?
Act 2 of 1940.
Yes.
Can you see section 4?
Yes.
আমার কাছে বই নেই।
Heading is acquisition of land. Where any land has been acquisition under section 3, the state government by use or deal with such land for any purpose referred to subsection 1 of section 3 as may be appeared to be expedient. The state government may by acquire of any land acquisition under section 3 by publishing the official gazette, that such land is required for a public purpose referred to subsection 1, where such notice is approached published in the official gazette. We have placed before us that the acquisition land shall on from the date of beginning of the date notice published shall vest absolutely the state government free from all incumbency, and the period of acquisition of such land shall end. But this section 4 subsection 2 has not been challenged, or this was still valid till 31st March 1997. On 31st March 1997, if the land was vested to the state under section 4 subsection 2,
Vested free from all encumbrances.
Free from all encumbrances. Can that order of vesting, which took place in more than 30 years, cannot be set aside by today by filing a writ petition in 2017? Because in the meantime, from 2017 or 96 to 2017, many facts have been taken place, transfer has been taken place, because some other side has changed their position. If wants to undo all these things, then there must be some explanation. Who will compensate? Government will compensate it, the petitioner. When 4.2, although it is not for me, never challenge. He could have said, no, this vesting is illegal. That has not been said. Only he said, prayer, entire land acquisition proceedings to be set aside.
No such prayer is there.
Yes. Can you see the prayer?
You have said awards to award in the laboratory.
Read or nature of mandamas, page 891. Directions are declaring the award declared dated on 27 October 95 and 12th August 96 in LKS number such and such, situated in line Mauja, Topsia, within police station previously Taligan, subsequently PS Jadavpur, thereafter PS Tindala, presently with Pragati Maidan under Rastoil Undivided District 21, now under the Suda, a read in the nature of mandamas commanding respondents who do the acquisition proceeding in CS number such and such, such and such. But can it be declared after 3 years? Because limitation is under the Limitation Act. 3 years.
Yes.
Assuming for a moment that order passed on 27th October 1995, when an order was published, that order is invalid on the ground of that Act of 1948 has been lapsed.
That is not.
Yes.
And section 7 capital A was amended when? And that is at page, sorry. Page 133 of the description. Act of 1948 was amended till 31st March 1997. That was substituted. And section page 133 of the writ petition. 2. Under section 2, kindly see. In subsection 4 of section 1 of the West Bengal Land, have you also got it? Land Requisition and Acquisition Act 1948, hereinafter referred to the Principal Act as reenacted with the West Bengal Requisition and Acquisition Act 1917. For the words and letters 31st March 1994, the words, figures and letters 31st March 1900 shall be substituted. This is a 94th amendment. And Madam, kindly see page 134, section 7, capital A, award by the collector. The collector shall make an award under subsection 2 of section 7 within a period of 3 years from the date of publication of the notice in the official gazette under subsection 1A of section 4. As the case may be, any charge is not made within period, the said period shall not be provided in case where the said notice has been published more than 2 years before the commencement of the Requisition and Acquisition Act 1948-94. The award shall be within the period of 1 year from the date of commencement of that act. Explanation. In completing the period of 3 years or 1 year as the case may be under this section, a period during which an action or proceeding shall be taken to the said notice as stated by court or court having jurisdiction shall be excluded. On a kindly see page 138, the award by the collector.
Yes.
Agreed by this brother, they have made a reference.
Yes, they went up to section 18 reference.
A reference. But in these facts, I did not to disturb your lordship's other judgments cited by the friend. And so far as the 2011 judgments are cited by my friend, that section 17 was dispensed with. Emergency clause was there. Here there are no emergency clause. Fact is different. 1970, 71, section 3.1 notice was issued. Section 4.1 notice issued on 3rd October 1980.
October 3, 1980.
1980. Page 118. Page 118 and page 120, description of the land. Now, when it was published, 3rd October 1980. Then from 3rd October 1980 to 2017, is there any explanation? No. And if the writ petition cannot be entertained because of the period of delay and lapses, then I did not go into the merits of the case.
Okay.
So far as making over possession by the third party, that would be, I cannot say, because state only requisition. Acquired the property, taken over possession, and handed over to the corporation. Now the corporation will say their case.
Okay, you have concluded. Yes. You are for the respondent number? Corporation. Corporation respondent number?
আমি তো নোট করে নিই কোথায়
3 and 4. Kolkata Municipal Corporation Commissioner. 3 and 4. Yes.
হ্যাঁ ঠিক আছে এটা জেরক্স করে দিয়ে দিস আমি এটাকে
Tomorrow? No, whether is it possible tomorrow? Yes.
It will be.
Next Friday, next Thursday, I have some BG code in the second half. Also 4th I can fix. I can fix on 4th. 4th of September.
But I prepared the short list of dates.
Yes.
May I permit to hand over?
Yes.
Next Friday, next
next
Thursday, it will be lordship. Very well.
Either tomorrow or 4th.
Tomorrow they are not ready. Tomorrow
I have got. You have already handed over it.
Copy আমরা যে এই কোনো ফটো তুলে নাও
Okay, please take down.
ডিস্টার্ব দিন আমাকে পুরোনোটা যে ডিস্টার্ব যেটা হাতে লেখাটা আছে এই
Argument on behalf of the state respondent number 1 and 2.
ডিস্টার্ব আছে তোমার কাছে
আছে তোমার কাছে ফেরত
আমি নিয়ে নেবো
Learned counsel appearing on behalf of the respondent number 3 and 4. Calcutta Municipal Corporation shall argue on 4th of September 2025 at 2 p.m. Let the matter appear in the list on 4th of September 2025 at 2 p.m.
I'm grateful to your lordship giving the indulgence to me.
Thank you.
You have every right to make argument.
Lordship, before your lordship rises, your lordship, I had mentioned the matter in the morning, your lordship. Item number 81 in your appellate side list, your lordship. Your lordship had granted me leave to mention the matter if it was not taken up today at the end of the day, your lordship. If your lordship kindly fixes a date for that matter, your lordship.
Item number
81 of your lordship's appellate side list, your lordship. 81.
এই কার্ডটা দিয়ে গেছে না আমার মোবাইল কার্ড দিয়ে গেছে
What do you want?
Your lordship, a date for hearing, your lordship.
It's 22.
Yes, your lordship.
Petition.
Yes,
What
your
is the
lordship.
urgency?
Your lordship, all pleadings are done, your lordship. If it has been pending since long, your lordship. If your lordship kindly fixes a date, your lordship.
You are for the petitioner.
I'm
for the petition.
I'm for the respondent, your lordship. I shall.
For the petitioner.
I shall serve them notice, your lordship.
No, no. Who is for the petitioner? I want to know. You are for the Haldia Municipal Authority.
I'm for WIDC, IIDC, your lordship.
Please take down. এই অ্যাপেলের সাইডে কি আছে? কেউ নেই? অর্ডার করতে হবে তো। নোট করুন, নিন, নিতে পারবেন? নিতে পারবেন, নিন। Item number 81. Item number 81. On mentioning by the respondent number?
Respondent number 4 to 6, your lordship.
4 to 6. This matter be fixed for hearing. Na, ki bolam bolo?
On mentioning by the respondent number 4 to 6
by the learned counsel for respondent number 4 to 6 column. By the learned counsel for 4 to 6, who submits that the pleadings have completed in this matter, so necessary date may be fixed for hearing. Considering the same, the matter be fixed for hearing on on 18th of September 2025
Grateful, Your Lordship.
at 12:30. Full stop. The respondent shall intimate the date of fixing this matter to the learned counsel for the petitioner.
Grateful, Your Lordship. Grateful.
Okay.